Hey, it's James, Father's Rights and Resources with the hashtag How I Got Custody. Going live on YouTube. I'm trying to get Facebook set up if I can here. Looks like it's not even. Oh, there's the option right there. It's not allowing me to flash off. Let's see here. Can I flip the screen? Trying to flip the screen so it's not showing my wall here. Dang. Okay. Well, let me just start talking. I don't want people to watch this later and then start being lost or get discouraged from even watching. Let me move this out a little bit. So you want to know what I did most of these past couple weeks? Got a whole bunch of people hitting me up, and it's hot where I'm at here. Got a whole bunch of people hitting me up and reaching out, saying they need help. And then when I tell them I charge them my time, they don't hear from them. That's about 90% of the people reaching out to me, which is kind of crazy because I'm the cheapest guy out here. And like I just showed in the testimonial, I've helped guys win all kinds of ways with or without an attorney. If they got an attorney, would light a fire on them. Let me see if I can clean this up. This might be a little dirty. Yeah, maybe it was a little bit. If you got an attorney, there's a way to light a fire under the attorney. If you don't have an attorney or you want to get rid of your attorney, then there's a way to deal with that too. I don't know if I'm going to make Facebook. I can't get my phone to. Oh. Okay. I'm being a little dumb with that. Okay. So it looks like I'm live on Facebook and YouTube. And I'm going to try and use my. Hey, everybody on Facebook, if you're watching. I'm trying to go live there. And anyway, most of what I was doing this past week was just having people say, hey, I really need help. I need help really bad. I could use help. I need a consult. And then I say, here's my rates. And I always thank everybody for reaching out to me when they do reach out. Because, they're willing to spend their time with me, get my help or whatever. Even though I'm kind of harsh and I tell people to grow balls. There's Drew Landon. Hey, James. Hey, Drew. I tell people to grow balls, be a warrior, stop being soft, all that kind of stuff. I still appreciate your time and the fact that you might have reached out to me or whatever. So that being said, it's still just kind of crazy that the average person, gets all mad at me because I charge for my time, or the majority of people actually. I don't think anybody has a problem with Judge Anthony or anybody else doing the same thing. I'm tilting my head way down to look at the laptop, so I'm going to move this around on Facebook if anybody's there. I don't know if I'll get anybody on Facebook. I thought I'd give it a try. Okay. So, I guess I'll be turning my head. So either way, I got to be up, down, or turning my head or something weird, So if you have any questions on here, feel free. Now's the time to ask. You can ask anything you want, actually. Some people have asked me, can you tell me why your baby's mom abandoned her after you got full custody and, things like that? I don't care. It is what it is, just for Memorial Day, I just posted, a little never forget thing. And I talked about the people who tried to destroy my life with my kid. I posted this on Facebook because I have a bunch of mutual friends with a guy I roomed with and that went to church with right out of college, was part of this community of folks that were in the same church. We did all kinds of stuff together. We were like family. We we did stuff together 3 or 4 times a week. We go to Mariners games together, Red Robin, hang out, go to movies, go to church stuff and things like that. We were around each other all the time. And some of us lived together and rented homes, like, right out of college. People, it's too much for rent at that time, or, everybody works. I'm a warehouse worker. Other people are doing basic right out of college jobs. I didn't finish college. I went back about, I was on the 20-year plan. I went back and got my degree, 2012. So I should have got it in 1992. Played a year of college basketball, transferred to University of Washington, dinked around with some community colleges, and I'm like, school is not for me. Especially just what I got going on. I'm just living a regular, average life, not doing anything too crazy or fancy, and spent a lot of time doing church stuff in the church I was in. But one guy that I lived with named Kimo Evans, Kimo Evans, he was a graphic arts designer, or at least he was. I don't know if he still does it. He ended up marrying a chick that I liked for a long time, and then I dated for just a couple weeks, and my baby's mom found out, and she wanted to kill her, so that ended that. And then she ended up her name was Mary. So Mary came to court and was the star witness of my baby's mom. My baby's mom hated her guts. So I got drama from like every angle, not just regular family court drama, but just insane stuff like that. And Kimo came to court writing a declaration, said I should never be responsible for a kid because I'm bipolar and got all these anger issues and stuff like that. And he had anger issues, and he had a marijuana issue, and he had a woman abusing issue and some other problems. And he was just mad that his eventual wife, Mary Solscheid, ended up, her at one time was flirting with both of us and making us both think that she liked us, or it crossed over or something like that. She continued to flirt with me when she was dating him, and I didn't even know. And I dated my baby's mom before and after Mary, so my baby's mom hated her. And right before my daughter was born, she was still calling Mary, my baby's mom, Sedaris, or Sid for short, was still calling Mary, a bitch, a whore, an airhead. Just a couple weeks before she had her as her star witness. Anyway, so Memorial Day the other day, that was 6 days ago. Memorial Day, I said, hey, never forget, these are the people who tried to destroy my life with my kid. I raised my daughter for 23 years. This is their legacy. Child abusing, child traffickers who wanted to take my kid away. And so I'm letting our mutual friends know how evil these people were, because they came to court thinking they'll never get found out, tried to destroy my life for the rest of my life with my kid, and destroy my kid's life, because if I don't have my kid in my life, she suffers. And they just moved on and happy-go-lucky. Everybody loves some stuff. They tried to destroy my life. I'm letting everybody know what their real legacy is. So I'm never forget it. I'm gonna let people know. If it affects them, fine. If it doesn't, fine. But letting people know the evil in this world. And it's funny, all those people were laughing at me, mocking me in court. And I walked out, eventually walked out and triumphed. over them. So anyway, somebody has a question already on YouTube. Drew is asking, hey, what's up? John from American Fathers is on. He said, hey, James, you're really great, brother. Appreciate what you do. Appreciate what you do too, John. That dude's a real one. He just did an interview with me. He's also kind of sick of the BS and people who aren't really real advocates and just kind of bluffing and playing games and just, putting up a front that they're here to help. And then when you want to network with people and stuff like that, or when you're talking about real issues and they say, no, we got the market on that and it's only us and it's only about us and our group and our people in our group making money or making a name for ourselves or getting famous. Those kind of people have been around. I mean, they're always around in any area of life, but I don't know how a dad who went through this, excuse me, who went through this stuff and talks about how corrupt family court is. We all know how corrupt it is. And then they come out of here and they're hustling guys and misleading them and pretending they know what they're talking about because they went to court. Present father, Randy Keefe, he keeps having people on his show, on his podcast, and they keep saying, oh, these guys think, and one time they were talking about me, these guys think they come out of their family law case and they know all the answers. And it takes years to figure this stuff out. And some guys think they got all the answers. And that's exactly what Randy's doing on his page. And he partially lost in court because his kids continue to be under the control of an alienated, abusive mother for long periods of unsupervised time. Anyway, these guys are such hypocrites. Let me get to Drew's question. I have a question involving mental health and the high conflict X. Best way to approach that so the judge listens because it is a big deal. Eddie Nava, or is it Nava? Let me know if I pronounce that wrong, dude. He said James is the truth. Thanks, man. So when it comes to mental health stuff, a lot of guys, the attorneys will tell you, oh, don't go to court and talk about her mental health. You're not a psychologist or a psychiatrist. You can't talk about it. And that's insane because women will say, oh, this guy's got mental problems, and they'll order a psych eval just because she said so. What you want to make sure that you do is you want to make sure that you say, look, I'm not a psychologist and diagnosing her, but there's enough preponderance that, you guys, the court is a preponderance evidence court. So you don't have to prove beyond a reasonable doubt that there's concern about mental health, which is the first step before you get help. Just like you can't say technically whether somebody's a drug addict or alcoholic. You could say his drinking has gotten so out of control, like, husband comes home drunk all the time or whatever. You can't really say whether that, now you can, but in court, you can't really say that he's an alcoholic, but you can, I'm just in the Facebook one, but you can say, look, they're showing signs of bipolar disorder. They're all over the map. One day they're like this, another day they're angry, another day they're depressed, and you can describe what they're doing. You can testify to what you see with your own eyes. You just can't go through and say the final diagnosis is they officially have bipolar disorder or this thing in the DSM-V or whatever. You can go to court. Well, I'm going to court. I'm saying, actually, if you got an alienator or somebody withholding kids, that's a great argument in and of itself, right from the jump, that's mental health problems. Because if you look at all the science, that I repeatedly talk about, you look at all the science, and the science says that it's dangerous to a child to not be with a father. It's an uncontested fact. I like using that phrase, uncontested fact, That saves the hassle. Anytime you can, if you know a phrase that saves time from telling your story, you shorten up your argument, especially if you only got a few minutes to talk. Saying this is an uncontested fact is meaning nobody's contesting it. It's not debatable. No one ever would debate it. It's a resolved issue in the court, in all of science, whatever. Because 100% of all studies show that children suffer without a father in the home full time. Now, most of them is without a father full time, and a lot of them, they all say involved father. So if 100% of studies say the more you push a father out, the more dangers there are for a child. And some people will say, oh, I turned out okay. I was single mom raised. Well, did you really? You don't have any issues in life that might be related to it. And some people are in denial about that stuff. But if they turn out okay and successful in life and they weren't a juvenile delinquent and stuff like that, that's fine. It doesn't say 100% of people. It just says these rates go up 10, 20, 30, 100, 400 times. So if something is 400 times a greater risk, like a child living in with a mother who has a step husband in the home or a stepfather in the home, the risk of child abuse goes up 400 times. So why wouldn't you place a kid with a safer parent if we're following the science and the data? Now, I say all that to say to answer Drew's question. This woman is pushing me out. She only wants me to be an every other weekend visitor in the child's life. It's an uncontested fact that every other weekend parenting plan puts the children at risk for mental health, teenage pregnancy, drugs, alcohol abuse, dropping out of school, all that kind of stuff. Nobody in their right mind would want that for their own children, even if they hate the other parent. They would never want that for the other children or for their children. Who would do that? No reasonable parent. And that's another phrase to use. Sometimes if you forget an argument or forget a statute, you can always say, well, no reasonable person would do this or any reasonable person would do that. Reasonable person is an invisible person who's always in the court. It's this angelic, righteous person who always does the right thing. So no reasonable person would do this. Or any reasonable person, no reasonable judge would believe what she's saying. No reasonable parent would withhold a child from their father when that's automatically dangerous to the children. Go ahead, hate. And when you go to court and do stuff like what I'm about to say, you go to court and you say, okay, go hate me. That's fine. I wasn't a great husband. I wasn't a great boyfriend, or we had our differences. And she could hate me or be upset with me as, you know, how loyal I was or how good I was or much of a provider. But you can't hate the children more than you, or hate me more than you love the children. We created kids together. You got to man up or own it. And you have to be willing to share the children in light of their best interest in order, because you want to do what's best for the kids if you care about your kids. No reasonable person would withhold a kid because they don't like how good of a boyfriend you were or how bad of a husband you were. No reasonable parent would do that. And so since no reasonable parent would, and now I'm getting to Drew's question, he was asking about how to deal with mental health, and it is very important. If no reasonable parent would play the game she's playing, and no reasonable parent would want to take a father away, no reasonable human being would say women are more important than men in the home. Nobody would say that, except this person. And she's so far departed from the norm that calls into question her mental health. And if she keeps making bad decisions for the kids like this, we have to get a psychological evaluation on her. See, I didn't diagnose her with anything saying that. I'm saying there's all these signs and stuff like that. And if you study narcissism, a dark triad narcissist, or bipolar disorder, or whatever, borderline personality disorder, you study those disorders, then you could say, and plus I've studied this, and they're showing the telltale signs of this, that, and that, and that, and rattle it off. Okay, you didn't diagnose them. You just gave the court a compelling reason to intervene and get a psychological evaluation. And then, like every dad, almost every dad I deal with, In Washington State, you have to propose a specific parenting plan, a final parenting plan that you want at the end of your case. Just like if you sue a doctor, think about when you file a court case, you sue a doctor for malpractice, you're going to want $100,000, $20,000 on the surgery. You had to get another surgery for $20,000, and you suffered $60,000 worth of pain and suffering. So you want $100,000. You put in your complaint, I pray for relief of $100,000, this and that. A prosecutor prays for relief. This pedophile should get charged with, this felony, that felony, and that felony. They should get life in prison. In Washington, they make you lay out the exact parenting plan. I want full custody every other weekend for her, 50-50, or every other weekend for her until she gets a psychological evaluation, completes recommended treatment, verifies that. I got samples of parenting plans in my store. There's a packet of parenting plans, and 100% of people, if they were to write up a parenting plan or trust their attorney, there's always something missed. And the parenting plan samples, I have a sample for 50-50, a sample for every other weekend, a sample for supervised visitation. And I have all these clauses in there, like first right of refusal that so many people don't put in their parenting plan. Yeah, for those who don't know, first right of refusal is you're the first person who has a right to refuse time with your kid. Basically, when the other parent needs a babysitter, they call them the parent first, the non-custodial parent or whoever's not having time. Right of first, they should call it first right to visitation or something like that. I don't know why they have these stupid backwards names. Even when they use English, it's weird. I know they use a Latin terms like, oh, this is fancy legalese and this is fancy law stuff. And we're using it to sound smart and to have a big circle jerk over how cool we are. So, I had to turn that one off. That's a client of mine who was on supervised visitation for 4 years, which was insane. But let me go back to, I'm trying to observe this on Facebook too to see if I'm okay. I'm trying to go back to I want to be able to monitor if I'm what it's looking like on Facebook. Anyway, so dealing with mental health stuff, you don't want to let anybody convince you to not bring up mental health because you're not a psychologist or psychiatrist or expert. Now, expert testimony is inadmissible unless you're an expert. ER 702 in most states. And you guys have to know the rules of evidence because that's what is allowed in or isn't allowed in. And the people who don't know the rules of evidence and we go over their case, half the stuff that the other side is talking about is inadmissible and they never even attempt to shut it down. You have to know the rules of evidence. Google them in your state. If you're in Tennessee, civil rules of evidence. Just make sure you don't have the federal court rules. They're exactly the same in most states, but they're exactly the same, but sometimes the numbering system between the states is different. Like California, New York. Sometimes people have an extra prefix number in front of them in some states too, but it's the same numbering system. So that being said, you don't want to be discouraged because your attorney says, oh, you're not a psychologist, so we can't even allege that. Women allege it all the time, and guys get psychological evaluations, or you get a parenting evaluator, or you get a guardian lie to them and say, oh, I'm really concerned about his mental health. He should get a psych eval. How come they get to do it, but you can't? So that goes back to like a video I just did where I was telling people, how come they can be aggressive? Whoops. Did I screw something up on here? Oh. How come they can be aggressive against you, but you can't be aggressive against them? It's open season in court. It's a war between two parties. How come you can't do the same thing they're doing? Women going to court and allege, oh my God, I can't even see it. Women go to court and allege all kinds of crazy stuff, including mental health problems. And Nobody questions, oh, you're not a psychologist. I'm not going to order a. And think about it. You're just saying they should get an evaluation. You're not even saying the final product. When they say it about you, you say, well, I don't, they can't testify to that. The judge will say, well, they raise concerns, so we're going to look into it. So, and then almost every state has a factor in the law that says the mental health of the parent. You know, if you're in Florida, 63.13.3, if you're in California, Family Code 3010 to like 3044, Washington, RCW 26.09, bunch of subsections 002 to 191. You know, I got links to a bunch of that stuff. You know, Illinois is 750 ILCS 602.5/5, I think it is. When you go into there, it says the court shall consider. And when you're reading the laws, you got to read every word. It says the court shall consider. It doesn't say the court may consider if they feel like. They have to consider all these factors: the bond between the parents, who's done the parenting functions, some places is primary caretaker. That's not in Washington. You have to look through all the factors, because you could steal a kid and be the primary caretaker. And that's an argument. If I was in a state where they said primary caretaker and the mother was withholding the child, I would say, well, she's only the primary caretaker by force. That should not be a factor that's applied here. But it does say shall consider this, that, the moral fitness of the parents. No reasonable parent could be deemed moral, or no reasonable judge will say they're moral when they're withholding a child a basic life need from a parent. Outside of food, water, and air, name something more important than a father. Think about that for a second. Outside of food, water, and air, the things that keep a child alive, name one thing more important than a father. I've actually asked some dads that, and one dad once told me television. Another one said friends. Another one said school. You are going to forever be the father of your kid. Your legacy with that kid is going to affect that kid after you're gone. There's nothing more important than you. And you say something like that in court, the other side is going to say, how dare you say he's the most important thing? I didn't say that. I said there's nothing more important. We're equally important. The fact that she just jumped all over that and was presumptuous with what I'm saying shows what ill character she is, or whatever you want to say about that. So you say it in a certain way to get the psychological eval. Once there's a problem, then you just got to be slick about how you say, if they have this problem, that will affect their judgment as a parent, and you got to exercise good judgment. In Washington State, RCW 2609.004 talks about parenting functions, and one of them is exercising appropriate judgment. Yeah, another is, bathing, clothing, cleaning. That's parenting functions. Another one is maintaining appropriate relationships. If she's depriving the child of a father, she's depriving the child of one of the two most important relationships in the world, and nothing else is even close. I had somebody ask me the other day, what about, and they say, oh, the mom's living with the parents, we don't want to, her parents, the grandparents, maternal grandparents. Mom's living with the parents, we don't want to disrupt that. Who the frick cares about grandparents? Almost nobody lives with their grandparents growing up, except for a small percentage of people. There's no study out there that says kids need grandparents. And if we're going to believe science in a court that shut down because of COVID, because you're supposed to believe the science and what the science says, which was mostly bullshit. But if we're going to believe the science, let's believe the science about the most important thing, how we deal with a child. And the judge's number one allegiance is to the welfare of the child. And if a parent has a judgment problem that affects their parenting decisions, then that's going to be a problem for the child. And if you could twist and turn everything, this isn't about me versus her as much as what's the best for the child, what's the best environment, what's the best interest of the child, Your Honor? A toxic home, a non-toxic home, or to the question that was asked by Drew, a home with mental illness or a home with a clean bill of health, a home with alienation or a home where the other parent's honored, a home with violence or a home that's peaceful. Sometimes you got to lay it out like that and talk to a judge like they're in his second grade, because there's an optics thing that goes on in court. If you watch any movie, Law and Order, any movie with a trial or an argument, A Few Good Men, JFK, A Time to Kill, or Law and Order, anything like that, The Practice. I really liked that show in the late 90s. a lot of times the winning argument is the one that tugged emotionally on the judge or jury the best. You still have the facts and the evidence, but it takes it over the top. You know, Johnny Cochran had the famous line in the O.J. Simpson case: "If the glove doesn't fit, you must acquit." And the prosecutor at O.J. Simpson trying a glove that they found at the crime scene, and he was pulling on it, and and it didn't fit. And he said, if the glove doesn't fit, you must acquit, or if it doesn't fit, you must acquit. That drove home. That went viral, if you could say viral back then on television. And so that might have helped get them over the hump. You know, the jury, when they did the exit polls, they're like, we watched this for 9 months. They didn't prove anything. And they got to prove beyond a reasonable doubt. So whether you believe he's guilty or not, you know, that's not the point. I'm making a lesson out of this. But when you're dealing with a psychological evaluation, you want to get it across to the court. They should be concerned enough. There's enough evidence to be concerned about the welfare of the child, how their decision-making is affected. And the example I was given in Washington law says that the court has to consider who's been performing parenting duties or doing them better. And if parenting duties, bathing, clothing, cleaning, feeding, taking them to school and all that stuff. But then there's these other ones, maintaining appropriate relationships, and they're withholding the most important relationship. You can find this in RCW 26.09.004. I think it's subsection 3. And then same chapter 2609, 191 says, if you refuse to perform parenting functions, they have to put restrictions on you and limit your access to the child. If you neglect to perform parenting functions at a lower level of it, they can put restrictions on you. Well, if she's withholding a child and then she's not exercising good judgment, those all tied to withholding the child, depriving the child of appropriate relationships, then she's flunking that factor and she's refusing or neglecting to perform parenting duties, you should have custody. So when you look at the law, know the law, and then you do a math equation, 1 + 1 = this. She's doing this. The law says you have to consider that. I should have custody. We're doing what's best for the kids. And most states have a law that says the mental health of a parent. And then you can just add your own lines. Like, look, people who have bipolar disorder, they're all over the map. There's nothing consistent. And she's already shown signs of, and when she's emotionally triggered in her rage, she'll withhold the children. That affects her parenting. Now, I'm not knocking that she has a mental disorder, but it affects her parenting and it affects the kids. That's if you want to put it nicely. Anyway, hopefully that answered. If I didn't answer your question, Drew, just elaborate and ask something more detailed. Is anything told to the judge about why mediation did or didn't work? Okay. That's an interesting question, because if you know the rules of evidence, you guys could do it now while you're here. Look, Google evidence rule 408 with your state. If you're in Minnesota, ER 408. The federal rules are the same for federal court. You know, none of you guys are in federal court, but it's the same rule that applies, and almost every state adopts that exact rule with the same number. ER 408 says offers to compromise are not admitted in court. A lot of people don't know this. And I have an evidence rule video on my store that's 1 hour and 20 minutes where I go over the most important evidence rules, how I object, how I defend against them, how I circle their paperwork and parts that the evidence rules violate or something they screwed up on, so that the court doesn't consider that. It's really still, it's 1 hour and 20 minutes, and it's half the cost of, well, let's see. Yeah, it's half the cost of spending 1 hour and 20 minutes with me. You can watch it over and over and over again. There's no way you're going to absorb it the first run through. But ER 408 says offers to compromise are not admissible. Most of you guys know that hearsay is not admissible in court. You can't go on and say, oh, the mother told me that, or the father told me that, or the kids told me that. Objection, hearsay. Why is that? Because hearsay is not reliable. The story changes through the grapevine. One person says something, another person adds a word, another person adds a word, and by the time it gets to you, the story's off. Hearsay is not admissible. And you don't remember it that well if you're the first direct person to hear it. So you're not allowed to say what you heard somebody else say. They have to say it on the stand in court or in a declaration. And a lot of people don't understand. They're like, well, I saw them with my own eyes when they were saying this. I directly heard it. if you tell the court what you heard them say, that's hearsay. If you can't get that, you need to think harder about that. Use a little common sense and deductive reasoning. The person who said something, you can't quote them. They have to admit in court, I said this. That's why a deposition is so important. You get rid of hearsay problems. You ask the person up front, did you do this? Did you say this? Did you say that? And then you go to court with it. A lot of people just go to court, get caught with their pants down. They ignore me that I tell you should do a deposition when you got an attorney. If you got an attorney, it's the most important weapon available to you. Why do you think people use depositions all the time in regular lawsuits? If you Google, some of the most famous depositions out there are some of them Bill Gates had a famous deposition when Microsoft was sued by the government for antitrust violations, and they settled out of court. 95% of court cases are settled. That's what I talked to you guys about. Lil Wayne was being sued for something. The rapper Lil Wayne, he practically threatened the opposing attorney, and he was kind of smart with the way that he was dealing with him, because the guy was asking him dumb questions or leading questions. He's like, I don't have to answer that, or I don't know. And they're like, you're playing games with me. And he told the guy, he goes, he can't protect you outside, right? Like, he was saying that whatever officer of the court was there or something like that, or another attorney, he can't protect you outside. Like, what does that mean? He goes, oh, I was just talking to myself. But when you make an offer to compromise, it's just like a plea deal in criminal court. Let's say you're charged with assault. The prosecutor comes to you. Let's say you walk across somebody's, sorry about the background noise. I got to have the window open where I'm at here. There's traffic right out there. But if you haven't, like, you're charged with walking across somebody's grass and you step on their flowers, and so there's damage of property. It's an old lady. She was scared of you because you're a big dude. And then they go into crazy stuff like terroristic threat and harassment. And they got like 5 counts against you. And they say, you know what? Just cop a plea to the trespassing and we'll have you do community service and yada, yada. That's an offer to compromise outside of court. Same thing with mediation or negotiation. If you negotiate outside of court and they come to court and say, I'm not really guilty, the prosecutor offered me this. Or Bill Gates says, you know what? They were telling me in settlement talks that they only want 10 million out of me, and they're suing me for 2 billion. They don't really believe this. If you could use mediation talks or offers to compromise or settlement talks or a plea deal, if you can use that against somebody when you go to trial, nobody would ever settle out of court. There's a protection with that, supposedly, with the ER 408. Evidence Rule 408, offers to compromise. There's a protection with that. And that is, we want people, the court's like, we want people to settle out of court, because 95% of court cases settle out of court. If 100% of court cases went to trial, you wouldn't have trial for 10 years. The courts would be so backed up. And that's what happened in the Prohibition movement. When alcohol was made to be illegal, all the mafia folks who made moonshine and alcohol underground or sold it on the black market or whatever, they took their cases all the way to trial because they were confident in their lawyers, or they probably threatened jurors or whatever. And the courts were bogged down with alcohol cases. So they didn't change the law just because it was a good thing that they're protecting people from the drug of alcohol. It was the courts were tied up. So the courts would be tied up if you could use those if you knew that they were good, you're supposed to be able to negotiate freely and confidently without it being used against you, or vice versa. If somebody thought their talks could be used against you, then Brian Heel on Facebook says nothing is more important. And tell me if I said your name wrong, dude. But he said nothing's more important. I'm not sure what you're talking about. Nothing more than what is more important. The confidence of being able to settle out of court or in secrecy. But if that could be used against you in court, you would never settle out of court, and all the cases would go to trial. They need to protect the integrity of settlement negotiations and the confidence of that, and not having to worry about being used against you, so people can speak freely and so they can settle out of court. They say, well, I'll give you this. No, I'll take that. No, I'll take it. Just like when you're bartering and negotiating. Well, I want 50-50. No, I'll never give you 50-50. It's 90-10. Well, come on. You got to give me closer. Okay, 80-20. But you're still a domestic violence perpetrator. If I'm a domestic violence perpetrator, why do you want to give me 20%? Oh, back to 90-10. Okay, well, I'll just take it to trial then. Okay, I don't want to go to trial. Okay, 70-30, and they get closer to 50-50. If you use those admissions in court, you can make somebody look stupid. But they want you to settle out of court, so they make offers to compromise and mediation private. Now, states like California, the mediator makes a report to the court about how mediation went and then gives a recommendation. That's totally in violation of ER 408. And if you understand the rules of evidence were created to have a fair court procedure. Just like the rules in football are, you can't hit somebody after the play. You can't punch somebody in the groin at the bottom of the pile. You know, basketball, you have to shoot the ball before the clock goes off. You can't shoot after. You can't goaltend. All these things that make the game fair, you have rules. The evidence rules, it's in case law that they were created for a fair hearing. If you don't have a fair hearing, you don't have due process. If you don't have due process, the judgment or the decision is void. You had an unfair hearing and there's a judgment, 50-50, 60-10, 60-40, 90-10 visitation, supervised visitation. You can't see your kids, whatever. If the evidence rules were violated and the evidence rules protect and make sure that the hearing is fair, then you had an unfair hearing. See, the more you know, the more you put the evidence rules with due process and a fair hearing and case law. If you know all this stuff, then you could put two and two together and say, we had a hearing that's void because you let the evidence rules get violated. Or when you're in court, you say objection, ER 408. And the judge says, let them talk. And then you could talk. Your Honor, that's not allowed to be in the court at all. It's not allowed to come in and build a nest in your head, influence you. And then I got to tell you, oh, strike that from your memory, Your Honor. That's inadmissible. That's here and now. The evidence rules were created for a fair hearing. If you let them be violated right now, we have an unfair hearing. The judgment is void. See, when you come with an arsenal like that to the court, you know, people tell me all the time in my videos, oh, the courts don't do that. They're not fair. Did you go to court with that whole arsenal? Did you tell them the whole argument? Well, no, I didn't say it like that. And I'll even do consults with people, and I'll say, there's this, that, and that. Did you say, because they'll say, oh, I already tried hard in court. Did you tell them this, that, and that? Yeah. You said those exact same words that I just said. Well, I didn't say it like that. Mother effort, I just told you. Did you say it like that? This is another thing. There's a problem with dads. You can't hear or listen or pay attention and absorb stuff. So when you go to court and a judge asks you a question and you just dance around the answer, they say, okay, she alleged a DV. Were you at the mall that day when you saw, she says you saw her? Well, Your Honor, you know, we've been going to the mall for like 20 years and sometimes I go and sometimes I don't. And, you know, I like to shop that's where I get my jeans and some of my, you know, casual shirts. The judge is going to hate your guts because you can't get right to the answer. When you're in court, you have to answer the question and then elaborate. And if you're talking to me and I ask you, did you do this? Don't lie to me. Like, don't lie to me. One of my favorite attorneys, I only liked 5 of them in 25 years. One of my favorite attorneys, she was totally cool with men, fighting for fathers' rights. She hated women. And she was a big, butch, manly woman, which was kind of ironic. And maybe because she was a tomboyish, she grew up with a dad. So she hates crazy women. I don't know. But she said, you know, she had only had 2 requirements of her clients. And she was just like, you know, don't something with money, don't something with money, and don't lie to me. Outside of that, she's cool with you. She'll work with you. But people lie to me all the time when I'm doing a consult. I ask them a straight up question and they're acting like they're on the stand and I'm just trying to get down to help them. And they get all defensive and protective, or they just lie. Or they don't pay attention. They think it's no big deal. I said, go in there, let's think about losing weight. I give examples over and over because it's what people can relate to. If your trainer says, Only eat 3 meals a day. No, or 2 meals a day, intermittent fasting. You know, only eat vegetables and fruit here, raw food, and you can have one cheat night every other night, have a piece of cake or something like that. And then, you're still stuck on the same weight, or you're supposed to have lost 30 pounds in 3 months and you lost 7. And then the trainer has a meeting with you in a training session. Like, did you do everything I said? Yep. Did you have 2 meals a day and do this and that? Yep, I did. And then you're leaving out the part that you ate cake for breakfast, lunch, and dinner. You're lying to them. Why would you lie to somebody like that that's trying to help you? I get that all the time. When I say this is the stuff that works, it's the stuff I'm talking about. And if you didn't do that and you say, well, I did that and it didn't work, you're lying to me. But the answer to the evidence rules thing, the question was, is anything told the judge about why mediation did or did not work? It's supposed to be none of the judge's business. But in states like California, where they allow it and the media reports it, they could say, oh, the father was being obnoxious at mediation. He didn't even want to work with her. You don't have any obligation to work with somebody that's trying to take something from you, especially if they took you to court to sue you. I don't have any obligation. And see, if you know your rights and your right to take a stand, and your right under Troxel versus Granville and equality and the doctrines of fairness and equity, if you know everything you need to know, you know how to answer some bullcrap 4 or 5 different ways, or to pile it on to make them look stupid. But 90% of the people I deal with, even after they get the information, they half-ass it. They don't read it. They don't listen. They don't care. I had a guy I was dealing with for a while. He had a great shot at getting full custody of his kid. And he wouldn't pick up his kid from a preschool that the kid didn't have to go to. He was like, I'm not going to play those games and withhold the kid. She just withheld the kid for 3 weeks and 2 weeks. They were doing 50-50, and she did several withholdings. He's like, oh, I'm not going to play her game. And then so I worked with him. He got the paperwork together. He's supposed to file in his county. They're in 2 different counties. He goofed around. He was lazy. And then the day that he was going to file, she served him paperwork because she beat him to it in her county. So he had to go out of his way to go to her county, which was probably more mother friendly. He didn't listen to what I had to say. He was too lazy about it. Had no sense of urgency. And then he didn't get his kid, and the mother got the kid from school and pulled the kid out of school. So because he wanted to be nice and didn't want to hurt her feelings, he wanted to win points in his own mind with his own ethics or his own morality. You're in a war. Your little morality or brownie points that you're going to get from the Cub Scouts doesn't mean jack squat. That's why the fathers' rights movement, those guys are a bunch of weirdo pussies who say, oh, we're not going to ask for more than 50-50 because 50-50 is just because both parents are equal. Actually, they're not. Do you think women can equally protect kids like a man can? If somebody breaks through the door of your house and you're married, does everybody hide behind the wife or hide behind the husband? And when there's a funny noise, does the wife go looking one night and the husband goes looking the next night? We're bigger and stronger. That nobody in their right mind would say women can protect as much as maybe some of these millennial airheaded chicks that you see on the street doing street interviews and saying stupid stuff. But the fathers' rights movement folks, they're saying kids should be with the mom 50% of the time, so they should be in danger to being molested and abused. And if she has a new husband or a boyfriend she moves in, child abuse goes up 400 times. They're all cool with that because they're a bunch of simp pussies. They won't even try and go for full custody with the strategy of maybe if I shoot for the stars, hopefully I'll hit the moon and get halfway there. They don't even like that. I've dealt with them for several years, and I come on and I'll say, I see somebody say something on Facebook and I'll say this and that, that's bullcrap. I'm like, how do you know? You don't know anything. Do you see my username? How I got custody? Do you have custody? No, I'm on supervised visitation. Then who the hell do you think you are talking to me like that? I've been around 25 years. How long you been around? Oh, I just got served divorce papers a month ago. And it's not about me. It's about the reality of recognizing if you're a basketball coach and you go to a camp for coaches that's ran by Pat Riley or I don't know, some Hall of Fame coach, or a basketball camp run by Michael Jordan, say, well, how do you know what you're talking about? Well, the effort, do you recognize who you're talking to? See, nobody wants the truth. Everybody in all these fathers' rights groups and pages where they're all giving each other legal advice, guys who lost in court are allowed to give legal advice to other dads who lost in court. All these stupid ass pages on Facebook and stuff, they just leave it wide open, and then people just throw their 2 cents in, and they might say something, if a dad follows that advice, that will screw his case. That's what pisses me off more than anything. I've said several times, I went on the Idaho Fathers' Rights Movement page. A dad was saying, my baby's mom, her boyfriend is molesting my daughter. I don't want to give her back. Some stupid jackass got on there and said, you have to. The law says you have to. And I said, what law? Show me the law. So I tell you guys all the time, when somebody says something, demand, what's the legal authority? Where do you get that from? Always have that question in the back of your head. If you get anything out of this video, always ask, where do you get that from? If a clerk at the courthouse, a judge, a lawyer, the mediator, somebody says you have to do this, you can't do that. Okay, where do you get that from? Well, that's just the way we do it. Okay, where's the law or the rule that says that? If you think somebody makes a weird move in chess or Monopoly, and there's a debate over whether you can do that, what do? You go to the rule book. You don't just sit there and argue back and forth. Like, what does the rule book say? Okay, where's your rule or law that says that? Anyway, so I demanded him to show the law. It took him like 20 minutes to go find it, and then it popped up. And the headline said, yeah, if you withhold a child, and then it says you could get in trouble. It's a Class C felony or gross misdemeanor. And then there's a line, another line, I can't remember. It's like the fourth line. It says, unless you're doing it to protect the safety of a child. So this stupid ass idiot, sellout piece of shit dad got on there and said, you have to give the kid back to a child molester. And he cited the law that he only read the headline of that. You see how when I talk about these stupid mother effers and these stupid freaking groups out here, how stupid they are? And then one time I got on there and the head guy, I think the head of the Father's Right movement nationally is some guy in Ohio, some punk ass bitch coward. I talked to him about some other stuff. They wouldn't go to Michigan when this dad was getting thrown in jail. You know, he's like, oh, he broke the law. We can't, and plus we got to kiss ass with politicians. We can't defend somebody who broke the law. And the guy was acquitted of criminal contempt. And it was a free speech issue. And these punk ass cowards wouldn't that would have been a great. It was in Michigan. Dad was found in contempt, talking about his case. Judge told him not to. The court acquitted him. And like the jury came out in like 10 minutes after deliberating. There's a First Amendment rights. See, nobody cares about family court. But when you talk about somebody's First Amendment rights, if those guys would have descended and used all their resources to protest out there, get it on the news, that would have been the notoriety that they're looking for. And this mother effer told me, well, that guy broke the law. He didn't break the law. He violated an order that was unlawful and violated the Constitution. And the faggot that runs the Father's Rights Movement nationally, I think the guy out of Ohio, I don't know, because they're all secretive, because they can't show their face because they're a bunch of bitches. And then when they do show their face, they're a fruity, feminine wimp like Mark Ludwig, thinking that 50-50 laws will fix everything. But I can't remember if it was him, but I said, you guys are giving advice that men should give their kids back to pedophiles, and you don't even know the law. You don't even read the law that you quote, because the law gives the man an out to protect his kid. Now, hopefully, that dad, I can't even remember how that went down or if the dad even looked at my comment, because I said, that's utter bullshit. You didn't even read the stuff, you low IQ piece of shit. You were telling him to give his kids back to an abuser. And even if I risk if that was the law, I would still not send my kid back to be served up to a molester. Who the hell does that? All the fags on the Father's Rights Movement pages. Pussy ass bitches. And when I say stuff like what I just said in the past 10 seconds, I'm being nice about that. How do you serve your kid up to get molested knowing that there's a molester there? Now, the dad didn't want to do it, but how do you give somebody legal advice to do that? There are some dumb, low IQ, subhuman piece of crap mother effers giving advice out there. And you should be cautious. You should be like, I don't know what to do here. Hey, dude, I'm worried that you'll get in trouble. Just say that. Don't tell them you can't do that and then lie about the law. And then you don't even know how to find the law. The guy had to Google it and go dig it up. And then when he finally gave it to me, I read it and he didn't read it. And it said the guy had a reason to not give the kid over. That's enraging. That makes you want to choke somebody or pound your head against the wall. And I deal with this day after day after day after day. People thinking stupid, ignorant, idiot stuff like that. That's why I don't have time to give a 5-hour speech every time I criticize Mark Ludwig or Dad Talk Today. That pussy. I DM'd him one time. I think his name is Carlos. I DM'd him one time. I said, dude, all you have is negative interviews and negative stories. Why don't you get somebody on who's won in court to encourage people? You're just giving into the doom and gloom. He blocked me. He didn't even want to say, who are you talking about? I could say, oh, well, I'm one. I got other clients. It's not even about me. Why don't you do that? He blocked that because he's a pussy ass sellout bitch. When you go onto his page, when you go on to Dad Talk Today, the first thing you see is how to donate to him. And I had somebody call me and say, that guy's stealing money from in a dependency case. He's trying to get money from somebody he wasn't even related to in some kind of trust lawsuit or something like that. I don't know if it's true, but his wife also said that he's some kind of narcissistic abuser. So, there could be people against him, maybe not, but he hasn't shown any reason to believe or trust him. I show you guys my winning court orders. I got 1 million declarations from female friends of mine who trusted me to watch their kids or our kids play together. Women I dated, I'm still cool with. All kinds of stuff to verify my character. And, idiots like the guy who came on today saying, he came on my page when I was telling people what to say in court. Like, why don't you get on the offensive and say what you need to say? He was like, you brainwashed mother effer, F you. And then he blocked me. And then I went on his page and he was homeless and didn't see his kid. He has all this, the court system is unconstitutional and fascist and communist. Okay, that's great. Do you have your kid? I do. Do you? Then why are you calling me a brainwashed mother effer? I worked the system to get my kid. Yeah, it's a fascist system. Yeah, it's a communist system, whatever you want to say, rights violating system. We are in a partially tyrannical government right now, even though if we followed our constitution, we wouldn't be. But we don't follow it because we have evil humans in charge and in power and in positions of power. So, this guy comes on my page. He lost in court. And my question to him is, what have you accomplished with all your ranting and raving and your rage against the machine? What have you accomplished? I'm the brainwashed mother effer, and I got custody of my kid and raised her for 23 years and have a great relationship with her. And you're going to say F you to me? Why? Because men are so outraged and so filled with wrath, and they're so traumatized by the court. They'll even go against, like, if that guy called me, I might have been able to help him get access to his kid. And who knows, 50-50 or something even better. But we have all this infighting going on. And then we have a bunch of stupid idiots in the father's rights movement, all these groups that don't know what the hell they're doing. And the guy who told me, the leader of the father's rights movement, when he said, when I told him your Idaho guy said this guy should hand his kid over to a molester, he said, well, we can't control what's in our forums and this and that. Why don't you? If you're opening a forum and creating a platform where any stupid jackass can come in and give somebody advice that will harm a child, why don't you change your format? I didn't get an answer to that, because there's a bunch of dumb mother effers who are too stupid to use common sense God gave a monkey and fight the right way in their case. And those guys have been hating me for like 20 years. I didn't come out swinging like this, but I would tell them, hey, look, you need to get on the offensive. You need to fight the war of attrition. You need to do contempt when you can. And guys would say, who are you? You got lucky and blah, blah, blah. And they're just mad, hating, and jealous that I won. Or they have such a traumatic experience. They don't. That's where you're intransigent. You're a narcissist. You're so caught up in your own trauma, you don't want to hear somebody else win, just like any other hater. Oh, he only got that job or that position because he was kissing ass. Or that guy is only rich or a billionaire because he was fed a golden spoon. Oh, well, he actually grew up poor. Well, still. That's feminine drama queen hater shit. And it's all throughout father. So all these father's rights guys, they want to complain about how the system sucks. And here comes somebody who overcame the system, and then they want to shit on him. So you don't even want an answer. All you want to do is whine, cry, piss, and moan like a little bitch. At least, here I got people asking questions. They want answers. This is why nothing's changing. There's people who don't want answers. There's a few people here who want some answers. I didn't have a live session I could go to and ask questions. I was totally lost, and my mentor Bob Carls wouldn't answer the phone 2/3 of the time when I called because he was so burnt out from listening to like 2 or 3 consults a week. That burned him out. And he read stories and online articles and stuff like that, but he was so burnt out by it. You know, in my heyday, sometimes I'd have 3 to 5 consults a few days a week. So I'm listening to, you know, like, I don't know, what's that? Let's say it's 3:15. I might listen to 15 cases. That's emotionally draining to hear everybody's sad story and then telling them how to fight. And they're like, I can't. I'm scared. I'm like, dude, grow some balls and just try it. It worked for me. I can't. It's emotionally draining trying to pick somebody up out of the mud and tell them to shake it off and to fight. And then just to hear the horrific stories. And that's why when people see me talk, I don't even want to hear the bullcrap. I've heard every story there is to hear. I have the answer on how to fight. Why don't you want to get the answer? Oh, I want to just talk. Go to a therapist and do that. You want some help from me? I'm not the one for everybody to dump all their emotional baggage on me when I got the answer. That's worked for thousands of people before me. I learned from stories that I heard from people before me, myself, and people I worked with right afterward until now. Why would you not want the answer? It's insane. So let me get back to see if there's any questions here. So I went off on a tangent. Like I said, I could talk for days. If you guys gave me one subject and you want to just hear one subject, I could literally talk for a whole day on one subject and break it down. And usually, just like with anything else, if you don't know the foundation or the fundamental, like a vehicle, like if all you want to know is about fuel injection, you're still going to want to know about the parts that lead up to where the fuel is injected. I don't know anything about cars, applying the gas and how stuff works and how pressure and combustion works and all that other stuff or whatever. And you need to know a little bit more than just the quickie answer you want. Okay. Or if you want to know, like, when you need to rotate your tires or when you need to replace them, you need to know a little about the tread, the streets, the weather that you're going up against. If you're in Vegas or if you're in Seattle where it rains all the time, you might have different, gauges for that. So you need to know a whole context of stuff to fully understand stuff. Just like when I was answering the mediation question, I was answering the psychiatry question. I went back and talked about several different things because when you're going to court, the court has a way to operate. They got to be fair and equitable. There's due process. There's your right to be heard. There's the court rules on the time. There's the rules of evidence. And then there's a report for mediation. Well, we need to consider all these things when we get to the report of mediation. I actually, to answer the guy who was the one who did it, Sean Billiot. One time I heard about somebody reporting to a judge about what happened at mediation or a mediator threatening to do it. And I reported that all around the courthouse to make them, and I reported it to the mediator. And I said it was a violation of ER, this and that. And the person was doing it in confidence. And I don't know if I got the person fired, but they got talked to. So when I find out stuff, even if it's not my case, I'll go spend my own free time and do stuff. You guys have seen some of my protests. If you haven't, go type in protests on YouTube. Go to my YouTube channel and type in the magnifying glass, the search bar within a YouTube page, and type the word protest, and you'll see all kinds of protests I've done for other people's cases that have nothing to do with me. And some judges started changing their rulings because they were embarrassed about those protests. Okay, would it be beneficial? So RLZY1ZH. Sorry it took so long to get to this. This is right after the last question. Would it be beneficial? I'm going to try and keep the answer short from here on out. Would it be beneficial to do multiple targeted RFOs, requests for order? That sounds like California language. If the judge is not letting me have any contact with my kids for over 2.5 years and there's no accusations and no restraining orders. Well, if you have a court order that's in place right now, you said the judge isn't letting you. What does that mean? Does the judge have an order? Or you went to court and tried and then got denied and there is no order? If there's an order, like in Washington State, there's case law that says the courts can change their temporary orders at any time. Those are temporary orders until you go to trial. Have you had a trial and you're talking about a final order that says you got 0 visitation? because that would be a violation of your constitutional right under Troxel versus Granville. But if you're talking about request for order, that's usually in an open case. So I'll assume that you mean there's an open case, you haven't gone to trial, and you're getting nothing. I would go to court with it. I mean, seeing your kids is the most important thing. I wouldn't bomb them with multiple different requests for order. I would just request for time, but I would base it upon the science. Like if you are in California, California says we want frequent and continuing contact for the parents, and there's no finding of any danger. So your number one argument is the law says frequent and continuing contact. Troxel versus Granville says you assume that I do what's best for the kid. All the science says if I'm not involved, those kids are in danger. If the court doesn't order 50-50 now, you are endangering the kids, and your number one duty of care is to the welfare of the kids. So why are you not giving the kids what they need? It's like if we knew a medicine that helped their disease and you said, I'm ordering you not to give it to them, or if you ordered them not to have food and only drink water, you would be a child abuser. You're ordering them not to have a basic life need of a father. We believe in science in this court, don't we? Well, the science says this order, if you have an order given very limited time, or you don't have an order and they won't give you an order, they're endangering the child. If somebody knows, or a police officer knows, or somebody knows that a child is being abused or neglected or living in a closet, I just saw this couple that went to prison and they had a kid locked in a closet, feeding the kid dog food and tortured the kid. And it was the mom was the biological, but the father wasn't. A lot of times when you see in the news, you should pay attention and read all the way to the end and see if you can find out if that guy, mom and her boyfriend, or mom and her husband abuse this kid. See if that's actually the biological. It almost never is, but everybody assumes it. So that being said, I wouldn't bomb them with a bunch of stuff. I would just do one motion that's very thorough and it covers all the science, all the data, the public policy of that state. Like I said, if it's California, Family Code 3020B says we want kids to have frequent continuing contact. Texas Family Code 153001 says the same thing. I just seen a couple of different people on Facebook talking about how Texas is corrupt and they don't want fathers involved. The law says they do. So what's the problem? It's a corrupt judge. You got to attack the corrupt judge. Robert Garza's out there from Texas running around trying to change laws and stuff like that. He missed out on his kids 43 times to have them taken away, and he didn't do anything about it at the time, didn't sue the mother, didn't press charges for false reporting because he's a little sissy. And now he thinks he's going to fix the system. Now he's got 50-50, which is great. But now he's going to fix the system by charging people $450 an hour and saying, here's a kid to pass laws in your state. And he guarantees that his 10 new laws are going to work. And I've examined a couple of them. He's full of shit. He don't know what the hell he's talking about. And he doesn't want to hear it. That's why people don't like me. They don't want to hear the truth. So I would keep it simple. And you got to understand the basics. I have a package in my store that's a motion for 50-50 year custody. There's a declaration where I have a bunch of science attached, and I make arguments about presumptions of Troxel versus Granville, and you slip in your statutes in your state. I have links to statutes in different states. There's a great argument or declaration in support of whatever motion. There's a declaration template and a legal memo where you can put the law. You can have two separate documents or you can combine them. That thing's worth hundreds of dollars. And if you had an attorney write it up, it'd be $1,000. And you still got to change it according to your facts and stuff, but it gives you it's worth the $45 just for the structure of you getting going instead of a blank form. Let me do a quick check on a family situation here. I'll be back in less than 60 seconds. Hold on, you guys. Okay, sorry everybody. It's a little bit. Sorry about that. I lied. Sorry. Okay, so looks like I still got most of everybody here. Okay. Hopefully I answered that. Just one motion. I wouldn't say multiple targeted RFLs. If you're not seeing your kid, there's one issue. Without me knowing about what's going on in your case, that's how I know. It's scary stuff. Television hilarious? Huh? I'm not sure what you mean, Eddie. Okay. Drew, how crucial or beneficial is it to be able to show a consistent pattern of behavior from the ex, showing up late, canceling visits, interfering with holidays, vacations, refusal to discuss child's development? Some of those are petty issues, so you're going to have multiple different ones if you care to do something about that. Canceling visits or interfering with visits, you got to do contempt. I got a video on YouTube. Why aren't you doing contempt? Someone's violating the court order. That's contempt. You should give them held accountable for contempt. It's alienation. If the court order says, and this is one of the arguments on contempt, if the court order says, well, whatever the court order is, it's assumed the judge did what's in the best interest of the child because they're supposed to do what's in the best interest of a child. So the best interest of a child, the courts are supposed to do what's in the best interest of the child. Every state says that. If they grant an order, you have to assume that they did what's best for a child. So if they give you visitation, that visitation is best for the child, and the mother's interfering with that. She's taking away the best for the child. Why wouldn't she want the best for her kid? Why would the mother not want what's best for the children? The court ordered this is what's best for the children, and she won't do it. So she won't do what's best for the children. That calls into question her fitness. She should be found in contempt, and that should stop. If the child's best interest, if they have, I don't know, let's say the child has an infection and they need, amoxicillin or something like that. It's in their best interest to give that to them and use the bottle until it's finished, or else it's ineffective or it backfires or something like that because it only halfway kills the bad bacteria, whatever. If the doctor said that and you don't follow the doctor's orders, then you could be harming the welfare of the child. That's not what's best for the kid. That's a great example to you. Say if a doctor ordered this is what the child needs, this medicine, I'm the medicine for the child's soul and emotions and development. And the court ordered, deliver this medicine to the child on these days. And she said, no, I don't care. That's insane. No reasonable person would do that. That calls into question her mental health. So as part of this contempt motion, I'd ask for a psychological evaluation on her. If you have an open case, if you have a closed case, they'll only decide on contempt and make up time. And I've said this before on contempt on the first, they'll never give her jail time on the first contempt, but I'll say, this is a pattern with her. She withheld the child before I got a court order. She's withholding the child from a court order after a court order. A court order doesn't work with her. The only thing I think will work is jail time. Now, I don't want to go to jail, but what we should do is have a review hearing, find her in contempt, order makeup time, have a review hearing in a month. And if she hasn't done the makeup time, she goes to jail for every day that I miss. And then if she complies with the order, her freedom is in her hands. That's a contempt phrase. You have the keys to your freedom. Her freedom is in her hands. If she complies with the order, which she should do in the first place, then I call the court and I say, hey, the hearing can be stricken. There's total compliance. And then everything is fixed. And you may never have to see us again, Your Honor. The purpose of contempt is to course compliance with an order. That's case law. This is why you need to know how to look up case law. You have the best interest of the child argument I just mentioned, and then there's case law. Then there's a clever argument like, I want to fix this so you don't have to see us in court ever again on this issue, and hopefully she'll comply. The only reason we're here is because her non-compliance. She doesn't care about the best interest of the child, and you care about it, and I care about it. She doesn't. So we need to do something to coerce her compliance. Like our Supreme Court said in Jones versus Jones or Williams versus Williams. You guys should look up the case law on that. And so if you go in there and say that and you set it up like, I don't want her to go to jail, but I think the only thing that's going to stop this is the threat of jail time. So do that. And it's no harm, no foul, because all she has to do is comply. This, oh, that's harsh. She wants to go to jail. No, I want her to comply. And why would she complain that I'm asking about this when the way to alleviate it or avoid jail is just do what you're supposed to do in the first place? Kind of like if you think of any other example in life, like you're supposed to not drive over 20 miles an hour, the speed limit in a school zone, and you hit a kid. Well, the kid should be looking out. No, you were supposed to not drive that fast. You could have slammed on your brakes or whatever. Think you probably think of a better example than that. I would always do that on contempt. I didn't think about that till after I'd seen so many contempts. You know, there's a guy I had, and I could show you the orders if somebody wanted to see them in a console or whatever. There's a guy I had in the greater Seattle area. His ex-wife was in contempt like 3 times, and he did 3 contempt motions, and he did not get her found in contempt, but they ordered makeup time. So if he missed time, you order makeup time, that's contempt. Why wouldn't you find her in contempt? But he was arguing the wrong way. After he got a hold of me, he got her found in contempt 5 times within like 2 or 3 years. And in Washington, if you get somebody found in contempt twice within 3 years, that's grounds to change custody. His kid was too old by the time we did it. He didn't get a hold of me till later on. But mother was found in contempt 5 times. I think he was like 5 out of 6 in 3 years. But that's a great example where somebody else would tell me, oh, I already tried contempt. You didn't do it the right way. You didn't hear from somebody who won contempt. Who taught you how to do contempt? Oh, I just trusted my lawyer. Oh, I just trusted the family court facilitator. Oh, I just did it this way. See, if mother effers would just want to learn or want to try again or actually love their kids enough to fight for them, they would shut the hell up and listen to somebody who's done it before. And that's not just about me. That's the way it should be. When I went to father's rights meetings with the other parent or Dads Against Discrimination or Dennis Gack, the 2 guys who were my mentors, I shut the hell up because they knew everything I needed to know. So I shut up to learn from them. People don't have a teachable spirit nowadays. It's crazy. Anyway, hopefully I answered that. Okay, yeah, the consistency. So the pattern and stuff, sometimes it's in the law too. The pattern and consistency or who's been performing most of the parenting duties and stuff like that. You know, I mentioned Washington law. Parenting duties include exercising appropriate judgment, maintaining appropriate relationships. She's flunking parenting duties. And parenting duties are a factor for considering custody. You should give me custody because I don't do that. She does. But I would do contempt as soon as a violation happens. It's a complicated situation to get into, mental health. So thank you. Okay, you're welcome. I'm getting ready to file an appeal after filing revision, then reconsideration. Oh, you must be in Washington. Official Almate. The corrupt judge pretended I didn't provide working copies for the reconsideration hearing, and even his JA, judicial assistant, gave proof. I would do another reconsideration if they said something stupid on reconsideration. I've done 3 reconsiderations in a row before I went to the Court of Appeals. You know, when you guys look on my flow page and you see my 2 wins in the Court of Appeals, one of them is a reversal of a final decision. The other one is a discretionary review where I went up to the Court of Appeals. I had the mom was, let me see, this is bad. The mom filed a modification. We had a trial down the road. And somewhere in here, the judge made a bad decision. Somewhere in the middle, like where my face is. So somewhere in the middle, the judge made a bad decision, like right where my face is toward the end. So I went up to the Court of Appeals and asked them to intervene. They accepted review or discretionary review for an interlocutory decision. It's called interlocutory in some states. So they accepted review. When they accepted review, usually they're rejected because it's very rare to show that they were so abusive and crazy with their discretion that you need the Court of Appeals to come down in between in an open case. Now, a final case, when you go to a final case, it's finalized. You have an automatic right to an appeal. In the middle of the case, you have no right to an appeal. You can motion the court for discretionary review or interlocutory decision. You can kind of remember that. There's the word lock in there. They come in and unlock your case and open it when they have no access to it. And the abuse is so crazy that they have to intervene. They accepted review, so I won discretionary review. And then the mother said, you know what, I'll just drop the case down below here. And then because I was going to win. The fact that they accepted it showed it was so outrageous I was going to win. So I basically won. But when you look at that, I had 3 reconsiderations before I got a reversal. So I would do another reconsideration, even as JA gave proof. Here's the other thing. If you didn't have working copies for the judge, that's a mere technicality. You can ask the judge to take judicial notice of what's in the file. You can say, look, I did do working copies. Your clerk must not got them to you. That's an error on the court's part that shouldn't affect my case and my rights. And this would be such a travesty of justice. We're dealing with a constitutional right. We're dealing with the welfare of children, which is at stake. And you're going to say you didn't get working copies? But every time you file working copies, you should have a receipt yourself of that. Don't ever go to court. I don't know if you did or didn't, but don't ever go to court without something stamped, or just like a passport. You get stamped whatever country you go to, they stamp it. You went to France, Netherlands, Germany, Sweden, your passport has these stamps. If I'm going to do it by hand in person, I have 4 copies of stuff. I'm going to go, and this is how the order I usually do it, because I have a proof of service ready to go. So I'll go to the lawyer's office or to the mother's place and have a friend drop it off at the mother's place, but I can serve the opposing attorney. So I go to the attorney's office, drop it off, and I have my face. Let's say I have a motion, a notice of hearing, and a declaration in support of that motion. I have 3 documents. My copy, I don't need the full copy. I just take the page 1 of each one. So I have 3 pages. So I go to the lawyer's office. Do you have a received stamp? Yes. Okay, here it is. Stamp my copy. Boom, boom, boom. Received on this day. Then I go to the courthouse and I'll use their copy machine and I'll show the received stamp copies from the lawyer's office, and I'll fill out a proof of service and I'll say attached is the stamp copies, and boom, I'm at the courthouse. And if I go to the courthouse first and then I serve the other attorney, then I got to go back again with the proof of service. I do it in this order if I'm doing it in person like that. So then I have the proof of service and I have the attached stamps. Nobody will question that I served them. Then I go to the judge's mailroom, and at the courthouses usually have a date and time stamp. So then I stamp my copies. So I go to, when I'm in court, they say, I didn't get working copies. Here, I have the stamp right here. I was there. I dropped them off. Oh, no, you didn't. You just stamped. So I went all the way to the courthouse just to stamp it and not give you a copy. Are you serious? So the clerks have never made a mistake in the history of this court system existing? You can't tell me that's possible. But if it's e-filing, I go in with the e-receipt too. In Washington, if you provide working copies on the e-filing, in a lot of counties, there's a fee for it because they got to print it out and they got to do some extra work or whatever. There's some counties where you just have to give them a list of documents to look into the file because everything is on the computer. Like I got a laptop in front of me right now. So a judge can go look in the file. This is why you need to know your courthouse. You could say, Judge, I just asked you, just take judicial notice of what's in the file. It's sub number. I just showed in a couple of videos ago, I just showed this my docket, and each one has an index number. We call it a sub number out here. The original summons is 1, the petition is 2, my proposed parenting plan is 3, the birth certificate is 4, my final parenting plan is like 41, 42 is this, that, and the other. You could say, and this is why you should have a printout of your docket. I talk to people. I have videos where I tell people how to manage their case. You should have everything available for all these kind of things when you go to hearing. Your Honor, I ask you to take judicial notice of sub number 44, 45, and 46. That is my notice of hearing. That is my motion, is the declaration. If you didn't get working copies, this matter is so important. Why don't you print out a copy now and we can continue this hearing on a later date? They do continuances all the time for a good cause. And the judicial assistant is admitting that you guys got a copy, so you wouldn't want to do a travesty of injustice. Now, there's actually case law in my state that says, the rules on when you file, make sure the judge has a working copy. Those are the local county rules. There's state rules that everybody has to follow, and then each county has their own rules. In the county where Seattle's in, you have to give 14 days notice before a hearing, and you have to provide working copies to the judge. in front of a family law commissioner, you just give them a list of the documents and they go in the file and just read the PDFs and scroll through them. My judge, who took jurisdiction in my case, he preferred hard copies. He wanted to flip through them and have them in his lap at home and take them home and read through them and all that stuff. You can ask your judge at personal preference, if you want to. They might appreciate that courtesy. Get them on your good side a little bit, maybe. You want to use every little thing you can. But my judge, so where was I going with that? I just lost my train of thought. So when you know your courthouse, you know the rules, okay. Seattle, you got to give 14 days notice. A small town, like you guys have heard, maybe Walla Walla, Washington. I forget what song that's in. That's in the southeast corner of Washington. So if you go down to the south, here's Seattle over here near the Pacific Ocean, and southeast corner is Walla Walla, Washington. Well, their county is you got to give 1 week notice because it's a small courthouse. It's not as busy. So you have the different local rules. There's case law in Washington that says the court has inherent power to waive its local rules. Well, I can waive the rules on working copies. Let me just go in there, or let me go have them printed up, or let me do a continuance. You didn't provide working copies, but this is so important. Listen, see, when you understand all that you need to know, you could throw that at them because they do whatever they want. And if you give them a good reason to do what you want, you give yourself a better chance that they'll comply. If you say, hey, look, this is about, especially if it's a motion against you. Let's see if he said what. Getting ready to file appeal. Just pretending I didn't provide working copies. An appellate court different than superior court, or is it usually the same? Okay, let me get to your question. So anyway, there's case law that says they can waive their own local rules. Just to show how unfair they were. Our appellate court's different. Appellate courts are way different. When you go to the Court of Appeals, all you do is transfer the record up there and you brief them on where they got wrong. You do an appellate brief. So you transfer the record up. You don't get to redo the hearing. A lot of people think it's a new trial or something. No, you go up and you have you versus the other side, and you make oral argument of the record that was down below. They should have done this. They should have. And then they don't change the facts. People don't get this either. The lower court, say you're in superior court. This guy is in superior court. Maybe this is a Washington case. If you do a revision from commissioner to a judge, it's a de novo hearing. It's a do-over hearing. You get to start from fresh all over. You go to the Court of Appeals, they look at the record that's on file. You can't add something new, a new declaration in the Court of Appeals. They have to look at the evidence that the judge saw. So if you're not ready for the Court of Appeals, and you're like, man, I should have got another declaration for this person, or I didn't get these emails in, do a reconsideration and add new evidence based on CR 59. But if you go to the Court of Appeals, let's say you're found to commit domestic violence and they gave you 0 visitation. You go to the Court of Appeals and said, I should have got some visitation. You argue, I'm not a domestic violence perpetrator. They will say, no, you are a DV perpetrator. We will not change that finding of fact. We trust the finding of facts. They're called verities on appeal or truth on appeal. They will only say the court abused its discretion by giving you 0 visitation. They should have at least given you supervised. Or let's say you're a woman and then the man was found with domestic violence and then he got 50-50. The laws in Washington, RCW 2609-191-4, say that when you go to the Court of Appeal, they say that they must put restrictions on somebody with DV. This is probably a more clear example. So a woman goes up there, Court of Appeals, and says, he committed DV. They should have put restrictions on him. They gave him 50-50. There's no restrictions. They abuse their discretion. It's mandatory. They have to put restrictions on his access to the kid. Supervised, no overnights, no weekends. You have to take anger management. You have to get counseling or whatever. Certain restrictions have to be there, and they didn't put restrictions. That would be, given the fact of domestic violence, whether it's true or not, given the fact of domestic violence, the court has to do these things. They didn't do those things under law. They abused their discretion. So I'm just arguing they didn't apply the law right. But if you come in and say, well, I'm going to counter appeal, there should be no finding of domestic violence. You can't do that because the findings of facts are done. They will not change the finding of domestic violence. They will say, well, they abused their power or something. Now, if you have something like there was no fair hearing, or I didn't get heard, or they didn't consider my evidence, then that's a different issue that would cut at the root of that finding if you attack it. But if you say, no, the evidence wasn't clear, the evidence was clear. The judge, what the court of appeals say, well, the judge was there and saw you and your demeanor in court and all this other stuff. So they had intimate understanding of the case that they won't have in the court of appeals. So they don't disturb the findings of facts. Now that you know that, there is one exception to that. If there's no substantial evidence in the record supporting that finding, but it's an extreme situation, you got to prove that that absolutely didn't happen. Or she said you committed domestic violence. You got proof you're at Starbucks and she was at Burger King. You hit her in the parking lot and you got a receipt from Starbucks and the court didn't look at that or something like that, or they didn't care. You got to have some the lower court is either devoid of any evidence that supports that, or no reasonable judge would ever consider something like that, or the record is so void, or there's no substantive evidence in the record to support that, and it's an extreme situation. So you got to prove your case down below. Once they make a finding of fact, that's one thing that's different. They will keep that. That's the finding fact. Or let's say you make $4,000 a month and they imputed your income at $10,000 a month. You go to the court of appeals and you say, I don't make $10,000 a month. They don't care. The lower court made a finding of fact you do. If you say, hey, they didn't calculate it. I make 10, she makes 5, and they gave they made me, I'm supposed to be paying $1,000 a month. They made me pay $1,500. That's off the chart. That's where they're abusing their discretion. But you can't change the $10,000. They made a finding of fact you make. That's how much you make. Unless there's overwhelming evidence, or there is no substantial evidence to support that finding. So the presumption is you don't get to retry the case. So it's way different. There's no trial in the court of appeals. There's oral argument. So hopefully that answers that. But if you're going to the court of appeals, there's some convoluted stuff you're going to want to know. And if you're not sure, if you don't understand that, you should get a consult with me, especially if you're in Washington. I've been to the court of appeals like 10 times on different issues and 100 times with other people. I've had other people win reversals, and one guy won in the Supreme Court. I almost won in the Supreme Court, something I should have, but that's a whole nother story. Okay, representing yourself, please explain how do you start your hearing. Talk about your declaration first for the record. Call witnesses. Can you explain your case without being on the witness stand? It all depends. If everybody goes to trial at the end of your case and puts the witnesses on the stand and you take the stand. If you're talking about a motion hearing, it's the rules of your courthouse. Most courts across the country, you get 5, 10, 15 minutes to talk. You make oral argument, they make oral argument. I mean, if it's your motion, you argue, they argue, you argue like you're an attorney. Everything's on declaration stuff. So you're arguing with the declaration, the evidence says to the judge, as if you're an attorney. They argue, and then maybe you get rebuttal. Or you could say, hey, I go into court, you go in front of a commissioner, you got 5 minutes. You go in front of a judge, you got 10 minutes. Now, the judge at their discretion will let people ramble on and on and on. So that may happen in your case, maybe it won't. But you got to plan for what the rules are. So you got to check the rules. If you don't know how to look up the local rules, then you're missing some basics that you need a consult to learn that stuff. So there are some states where you have basically an evidentiary hearing and you're able to put people on the stand. There's a couple of states where you walk into court with your evidence. I still wouldn't do that. I wouldn't want to go into court and say, hey, here for the first time, but you could see this evidence. I would want that stuff on the file, because a lot of times these judges will take this stuff home and read it the night before and absorb it. I don't want to splash them with all this paperwork and have them try and figure it out right there and then. But if you're allowed to call witnesses, yeah, call witnesses. You can explain your case without being a witness on the stand if you have sworn testimony on paper. You talk about the testimony that's on paper. Now, if you're a pro se, they usually put you under oath, because if you say anything, you would be testifying. The attorneys can't testify. They do all the time, and that's why you need to know the evidence rules to shut that down. but they won't put an attorney under oath because they're not supposed to testify. But they do. They'll say stuff. Here's an example. If the mother says, so that's Drew asking, oh, Drew's an alcoholic, and she writes that in a declaration, or she says it on the stand. In his closing argument, the attorney can say, the father's an alcoholic. He needs some counseling and some chemical dependency evaluation and needs to follow up with treatment. If the attorney says, Your Honor, we believe that father's an alcoholic, and look at his face, he looks red and flushed. It looks like he's doing cocaine or some other substance. Objection, the attorney's testifying. He just added to the declaration. He's not allowed to do that. He's assumed to not know you and not be around you, so he can't be a witness. Plus, the rules of professional conduct, usually it's RPC 3.7, say an attorney can't testify. They have to step down and become a witness if they're going to be a witness. They can't be a lawyer and a witness in a case. With a couple of exceptions. They can testify that, hey, we filed this 3 months ago. It's in the file. This is the history of the record. They're testifying to facts. They can do that because it's assumed they're acquainted with that. But outside of that, a judge can't testify either. Judges testify all the time. You guys need to shut that down. You need to stop letting people get inadmissible evidence in here. If you have a declaration, so Drew, if you have a declaration on file, you could talk about the declaration. You say, I testified that this and that happened. I saw her. I was there when she hit me. She has a history of violence. She slapped me around. She did, and it could be just your word versus hers. But of course, you don't want just declarations. If you got pictures of a bloody lip after she hit you, then or a police report or whatever, you want to have that in court too. But as far as procedure, you're asking me which type of procedure and stuff. It depends on your court rules. So to go in depth on that, that would be that you'd need a one-on-one consult with that. We need to know what your rules are. Representing yourself, how do you properly do that hearing, the proper steps? You got to follow the court rules. The court rules say if you're going to file a motion, you want a temporary parenting plan, you want 50-50 right now, you have to get mandatory court forms. In California, there's RFOs, and in Washington, we have mandatory forms and motion for temporary order. Technically, as long as the substance of what you're saying includes everything, it should be okay, but they're going to mess with you. So you want to follow the mandatory forms. You want to know the court forms. You want to know any statewide rules, which usually are really generic, but most importantly, the local rules of your county. So if your county is King, like mine, King County local rules courthouse, and mostly every county across the country has a page for the county, and then it has a thing that says local rules. And most motion rules are under Civil Rule 7, and then there might be some special rules for family law on top of that. Don't quote me on that because some states do their own thing with their own numbering system, but most of the states follow the federal courthouse. Motion rules are Civil Rule 7 in the federal courthouse. They're Civil Rule 7 in Washington State. The local rule for Seattle is King County Local Civil Rules, KCLR, King County Local LCR. And then there's some family law rules, LFLR, Local Family Law Rules. So you have generic rules for judges, then there's family law rules because you first go in front of a family law commissioner. Some of you guys in some of your states, you go in front of a friend of the court, a magistrate, whatever else names they have for low-level judges. But you got to know the local rules, and they'll say and you could actually, if you want to see this as an example before you dive into your state, you can look at my state. You can Google King County local rules or King County LFLR, and you can see it says under LFLR 5. Now, I know I said 7. That's for the general rules in front of judges, but there's special rules in front of these special family law commissioners. So LFLR 5 and 6, in there it says you have to file a motion 14 days ahead of time. You can't have more than 25 pages of declaration. So if you write a motion and you swear under oath on page 3, that's 3 pages. Then you have a declaration 10 pages, that's 13. Then you have your mom writes a 2-pager and somebody else writes a 2-pager. And then you file a motion. They're going to respond and you want to reply to their response. You got 15 pages. You only got 10 pages left to reply. So I try and make the first set of stuff, I try and limit that. Some state, like in Tacoma, Pierce County, there's a 10-page limit to exhibits, which is insane because I've always gone to court with like 30 different exhibits. I have more exhibits than actual the page limit is. So, but you can make a special request and motion to extend the rule. But then also there's case law that says you can waive the local rules. So you see how I just said there's local rules, there's statewide rules, and there's local rules, and there's special family law. There's local rules for judges, and there's special family law rules for whoever you go in front of first, magistrate, a commissioner. But then there's case law that says they can waive their local rules. The local rules are just a guide to allow everybody. You got to think about this. Just allow everybody to do stuff in order. Think about pro basketball. They have a rule that you could take 1.5 steps. I don't even know what it is today, if it's 2.5 or 2 or whatever. But when I was a kid, it was at 1.5. If you take 2 steps or 2.5 and it's a wide open dunk and Michael Jordan does something crazy and the fans go wild, they're not going to call traveling because they're like, there's no harm, no foul here, right? So they let the rules are loosely applied. The overall thing is to entertain the fans. Same thing in court. The rules are loosely applied sometimes. Like it's not people like they broke the law. They were 1 day late and I had only 3 days to get ready instead of 4. That's not the law. That's a rule. The law is your rights and what the court's power is and stuff. The rules are just how do we set this up and get it orchestrated? And if something happens where the rules are violated and it was unfair or prejudicial to you, then you need to know case law about prejudice or how I'm just in general, the court isn't supposed to unfairly prejudice you. You have a constitutional right to be fully heard. That means enough time to prepare on top of whatever. So if somebody violates a rule and it jams you up and makes it late, or it's hard for you to get a response in, you don't get a response in, you say, I didn't have enough time to prepare. I have a fundamental fairness doctrine right to that. Or they say, you know what, you wrote a 5-page declaration. You're like, but I wanted to get 10 pages in and I didn't have a chance. That's all I could do. I didn't get served until the last minute. They were supposed to serve me 3 days earlier. They're late. And it harms me and prejudices me. And I didn't have enough fair time to get ready. I need a continuance. So you need to know all, again, you need to know all of everything. There's a lot that goes to it when you're asking a question like, how do I get ready for a hearing? There's no way I can answer that right here without doing a one-on-one with you to cover everything. And you need to know everything. But it starts with the local rules. Now, you could do it on your own. You could go look at the local rules and study. The guy who mentored me, when I first went to him, I needed to go to court and motion the court for a temporary parenting plan. He opens up the book. Let's see if I still got it here. No, I don't. I thought I did. Do I have the statewide rules? Nope. Oh, here we go. Here's one with the local rules. Washington annotated local rules. So this is going to be, where's the state rules? So what he did was, this is old. Washington's rules of, that's correction. Admission to practice rules, that's for attorneys. Rules of professional conduct for attorneys, somewhere in here. There we go. Civil rule. I need glasses, actually. Here goes Civil Rule 7. So I don't know if you guys are going to be able to see this, but this book, yeah, pleadings and motions. Does that show backwards or forward? Pleadings and motions. On the phone, it's going to be backwards. Nope. Is it? Yeah, it's backwards. Pleadings and motions. So it talks about pleadings, and it basically says you got to file a motion, you got to sign it, you got to attach your exhibits, make sure you check with the clerk. Really simple. But then when you get into the book on, it's only like half a page. When you get into the book, basically the most important is you have to sign your pleadings. But each county has rules like 14 days ahead of time, file. In King County and Seattle, you got to file with the clerk on the 6th floor. You got to do working copies in the judge's mailroom on the 2nd floor. In another city in King County, the county is divided in half. There's another court building in Kent, Washington, K-E-N-T, like Clark Kent. You have to file with the clerk on room 2C on the 2nd floor and Judges' working copies is in 2D. The family law commissioner's copies are on the first floor. All those details. There's too much to get into, so I can't really answer all that stuff. You need to know the local rules. Drew, hearing for contempt, by the way. Okay, contempt is its own, it's going to have its own rules. You need to have an order to show cause, which is a mini summons to summon somebody to personally appear in court. So you can't just file a regular motion and mail it to the other side and they're going to show up. Contempt is such a serious issue. And also, contempt can be used when your case is closed. So when your case is closed, you need a summons to summon somebody to court in their due process right to be personally served. And because contempt is just a motion, you're not starting a whole new modification or a whole new or divorce or custody proceeding or a relocation where you have a trial at the end. You're just having one hearing. So they have a procedure where you go get an order to appear, an order to show cause. So that's a different procedure. After I went through all that, you still got to know the rules. They'll have rules on contempt and proceedings. So there's some states where, or some counties where they're way out in the sticks, they just kept rules really simple and the lawyers just do stuff because they know how to do it and they don't have it written in the rules. That's where if there's a family law facilitator, a family court facilitator, or self-help department, that can be helpful. But a contempt motion is another set of rules too. So, okay, so official Almate got an answer. Good. Okay, Drew, you gotta answer. Okay, well, I've been on here for a couple hours. I'll just leave it at that. If you guys need a consult or need details, just call or text me, ask me a day and time. If we talk before I identify, I had a guy who called me. I haven't talked to him in like 12, 15 years. He's like, hey, James, you still doing the father's rights stuff? And I was like, yeah. He says, well, how are you doing? I said, fine. You know, if somebody calls me and they're calling me for a reason, they need to tell me the reason. Like, you don't just call a dentist off. If your tooth is hurting you and you call a dentist office and you go, hey, how you doing? How was lunch today? How's the weather on that side of town? Good. You guys are doing dentistry still, right? And you're the one calling me. Say something. And so the guy, he started talking. I'm like, wait, who, I need to know, who are you? He goes, oh, this is, let's say his name is Bobby. It's not, but say, oh, it's Bobby. You know, you helped me. I got custody of my kid a long time ago. I'm like, okay, well, why don't you say that at the beginning of the call? I mean, I'm like, what? You have an urgent situation. You need, and that guy, his kid was missing and the mom took off and he didn't know where she was. And he took advice from everybody except me and waited and waited and waited and said, oh, just be patient. She'll come back. And she didn't come back. And he already had a custody case before, so he knows better than that. And he only calls me when he decides he's going to finally do something a few weeks later. The next thing you know, she had a restraining order. We were ready to rock and roll. He's going to go to court the next day and get on the offensive. And he goofed around for so freaking long because some numbnuts a-hole who worked at his barbershop said, oh, just wait and just be patient. Instead of calling me. Like, hey, people, I don't understand it. People have said, like, you were my go-to before. So now when I'm in trouble, I'll ask everybody else except you, and I'll wait around, and then I'll call you when I'm so desperate. I'm paranoid that I think I better call James. Why don't you have that desperation in the beginning? Not for me or my help, but to get answers, period. If your kid is missing, why would you wait several weeks? Would you do that if you knew a total stranger kidnapped the kid? Oh, I trust the mother kidnapping the kid, and she has mental issues and stuff like that. Let me just be patient, patiently wait. Something's wrong with my gender when that stuff happens. We got to be smarter than this. And, you know, the people who hate on me or get mad at me, they say, well, I won contempt on the first try. And they're like, well, I lost contempt and I just quit doing it. Well, that's why you lost. Like earlier, I gave an example. A buddy of mine named Will, let's say his name is Will. Will went to court 3 different times, didn't argue colorfully enough, and she wasn't found in contempt. He got a hold of me. We changed his arguments and what he said, and she was found in contempt 5 out of 6 times. Maybe 5 out of 5. I think there's one that they let it slide. But I know five because it was not too long ago where he was saying that 5 times in 3 years, 2 times in 3 years, the grounds to change custody. So I don't know why people will just goof around and talk to everybody else. There's something wrong with my gender. I had to tell the guy, when you call somebody that you haven't heard from in 15 years, identify yourself. Don't expect me to just read your mind and start conversating about stuff, especially if I pick up the phone and we start talking. He wanted to start talking and have a consult. I was like, dude, I don't do free consults. Oh, okay. That's another reason this stuff is drained. Like, you guys have no idea the stuff that I go through where people just hound me and harass me. How come you cost money? And I'm helping people get their kids back. Most people who get their kids back spend less than $500 with me over the course of a few months. All these other a-holes out here. Randy Keith, $200, $250 an hour. Robert Garza, $450 an hour. Family Court Corner, $350 an hour. Judge Anthony, $950 an hour. And what results are they getting? I stopped counting about 2018 or so. I'd helped 300 guys that I know of that got full custody without an attorney, some of them with an attorney, mostly without. How can you even put a price on that? And I have to explain that to guys when they look like they want a consult, and I don't want to deny them that. And I got to explain it to them, and they're just like, F you. And then I have to listen to people's stories. And then sometimes people will call me up and they start talking like, look, man, if you want a consult, you got to pay for a consult. You can watch my free videos. What if you and this? I got 1,000 free videos. If you add up all the time on there, that's at least $50,000 that you would spend with an attorney. And you could type in almost any topic on there and get some free information. And then I do stuff like this. And still 90% of dudes out there are ungrateful or have an attitude. And then the vast majority of them will do stupid stuff like work with me, get a good result, or they might work with me and they'll half-ass it and they get a bad result and they're mad because they didn't do everything I said, which is insane. Because if your personal trainer has a regimen and let's say you have a personal trainer and you're 100 pounds overweight, your personal trainer lost 100, 200 pounds and they got abs, they're living proof that what they did works. And they give you a program and you don't follow it, and then you get mad and want your money back, or you lie to them because you want to hide the fact that you didn't do the program. You can say, look, I sloughed around, I messed up, I want to try again. And you're honest with them, then it's probably all good with the average person. But I get people lying to me, lying to themselves, playing games because they won't. A lot of times when I go through the questions and people tough it out with me, if somebody hasn't picked up their kid, there's a guy in California, he had a court order for every other weekend, and he stopped picking up his kid on the weekends because the mom told him not to. I'm like, why don't you go pick up your kid? Well, she said, I can't. I said, the hell you can't? There's a court order. Do you think your baby's mom overrules a judge? And the end of it, he had to say, I guess I was just being a pussy. I didn't say it, he did. The average person who goes like, and I say, why didn't you do that? Why didn't you do this? Well, I can't. The cop said so. Well, why don't you call the cops on her? Oh, the cops told me they can't do anything. You mother effing liar. You just told me the cops will arrest you. And now you're telling me, now that we're getting down to it, you tried the cops and they said they won't arrest anybody. So now you're lying to me. Why won't you just try and do it? Well, I'm afraid. Afraid of what? Oh, drama. Aren't you suffering not seeing your kid? Yes, it's very painful, but I'm afraid of the drama with the woman more than the pain of not seeing my kid. You're a pussy ass bitch. Now, a lot of times when I go through, if they have a paid consult and we go through that stuff, most people I don't have to go through that, but I've had certain situations where I go through that, and then some people get totally pissed. Why are you asking me that? I'm like, I'm asking you, why aren't you doing this? Like, they might have a good reason. There's been once in a while, some people have had a good reason. Like, I don't know, there was some long distance, or somebody was disabled, or their parenting plan was written weird or something. The vast majority of them don't. So I give them the benefit of the doubt and ask them, and they get pissed at me just asking them questions because they have to examine themselves, because I'm about getting to the truth. And most of my gender is a bunch of mother freaking pussy ass bitches. They don't want to fight for their kids. It hurts their butthole to have to get up and do some work. They want to pay an attorney to make it go away. It's not going away until you push back or until you smack the bully in the mouth. The bully is going to keep trying to take your lunch money. If you keep giving the bully your lunch money, just think about that. There are guys who say, well, I just wanted to get along. I didn't want to cause any problems. She's tormenting and abusing your kid. And you're saying, I don't want to rescue the kid from the torment because I don't want any problems. But see, in your head, all you're thinking is the drama with this chick. I can't stand the drama. It hurts my feelings and I want peace. I understand that as a man, you want peace. But now you're at war over your kid. You have to be a man and go and act like a warrior and go rescue your kids. Nobody's going to rescue your kids. Nobody gives a crap about you or your kids. You're the only one who cares about your kids. Who else is going to do it? Think about how insanely stupid that is, that a guardian ad litem, a judge, all these people just go home at the end of the day and collect their $100,000, $200,000 a year salary. They don't care. If they did care at the beginning of their career, this drains them so much they don't care now. These people don't care about your kid. The alienating parent doesn't care, and you do, and you're expecting somebody else to care enough to do something about it. You are the answer to your problem. I have a video on YouTube. You are the answer. You are the answer to your kid's dilemma and problem. Now, if you go all out and do everything from the very beginning, some people have done that with me, and they still got a crazy result. The kid moved far, the mom moved far away, the fix was in, that type of stuff. Sometimes people at the beginning of their case, they have an attorney who screws them over and sets them up so that it's hard. They didn't get custody. If the mother's trying to move away and you got 50-50 or you got custody, so you can't do it. And that's what you should have been going for before. So some people are stuck behind the 8 ball, or they dug themselves a grave before they got a hold of me. But the vast majority of people who fight the right way from the beginning with me get a good result, a relatively fair result, or it's not as bad as it would have been. And some people totally flip stuff around. I just did a video on testimony. A guy surprised me out of the blue. He made a comment saying that he got custody in 2024, and now he's suing the school for violating his rights, and he's taking them to federal court, and he's winning motions. They're trying to get it dismissed and have immunity. That dude's kicking ass, it sounds like. You're the only answer, and if you don't want to do it, then stop complaining about the result. I had a guy who, I started telling the story about the guy who was in one county, the mother was in another. He didn't do what I said. She went and took the kid out of school. He didn't want to take the kid from her. If he would have taken the kid out of school and filed in his own county, he could have got custody because she actually had a criminal case. But he sat back and acted like there was no danger. There was no nothing. And, if a dad has any kind of violence in his history, the woman automatically gets custody based off of that. This dad had a great case for that, and he didn't do anything I said. He goofed around, and then he got significant visitation, though, because he'd been doing 50-50. He got a lot of visitation, better than the average guy every week. I think it was a 4-3. So he's only one day off of 50-50. So you got a great deal. And I said, well, she's going to get child support. She can go back to the time you guys separated. He goes, what? And then he wanted to fight. Suddenly I said, well, you got to try again and appeal. It was a watch the case. You got to do a revision. What's the guarantees do I have? I said, I have no idea. But it's guaranteed that she'll get you on child support because she has custody. Oh, so you can guarantee that, but you can't guarantee the other. I'm like, dude, I can't predict the future. I can tell you what you did and how it affects here and now. But in the end, he just disappeared for a few months. And then there was a child support issue and he popped in and they just disappeared again. That's my gender. Like everybody's complaining and I know the answer. And then people hate me when I give them the answer because it causes work, and you got to put in work, and you got to inconvenience yourself, and you can't do the same. There's one guy, I saw a video somebody showed me on Instagram. Somebody from on the other side of the country showed me a video. Dude, James, this is in your back. I hate seeing this bullcrap. This is in your state. And some guy in Seattle who acts like a big tough guy and talks about how men are punks nowadays and he's self-made and all this other stuff. He's on his second baby mama. And he does a video. How come he's the stupidest thing is to tell dad you got to fight for your kids? What about the mother doing mental health help and co-parenting classes and stuff? Bitch, stop having kids with crazy women. How about she do this? You don't have to fight. You had a kid with a crazy woman, and now you're mad that the crazy woman is acting crazy. Stop having kids with crazy women, or take some accountability. Now that you had a kid with a crazy woman, I did it. I had a kid with a crazy woman. I was stupid. So there was hell to pay to get in my child's life. But fortunately, as soon as the conflict happened, I went to war immediately. And it turned out that's the way that it works, fighting. I didn't know that. All I knew was that I had to fight for my kid and go all out and do everything that I can. And I thought that's the way all guys fought. And my two mentors, Bob Carls and Dennis Gack, dadsamerica.org, which the website is gone now because those guys got burnt out. The National Brotherhood of Fathers' Rights, you could still, if you type in National Brotherhood of Fathers' Rights, or if you type in Dennis Gack, G-A-C, you'll still see him on Facebook. I don't know where else he might be. He mentored me. He's kind of a hustler. I paid him $600 to do a defense against protection order. And I got a packet for 40. That was a 2001. That's at least $1,000 now. I got a packet for $45 that defending against restraining order or false allegations. If you don't have a protection order, but she's falsely accusing you of abuse, I got a packet for $45 that's worth $600. But Dennis Gack, I gave him my information in a Word document and he jumbled it all up and it's all out of order. I had to rewrite the whole thing. And all I got out of it was kind of a structure that the way that I should say it. He had kind of a template for me to work with. So I wasted $600 with him, but he still had some great advice that helped me. So I took in the meat and spit out the bones. And see, I've been part of this stuff so long, I have no reservations about calling out these hustlers and these idiots because I've seen it before. I experienced it. I've experienced everything that you could possibly experience. Other than I haven't been falsely accused of molestation or DV, just, well, almost DV, but harassment, and she's afraid. And I was falsely accused. I'm dangerous to women and children. There's a line in there that the mother's attorney and she signed after I got full custody. Anyway, I'm rambling on. Guys need to grow some balls and go to war, and that's it. And you know, one thing that guys think they have when they're arguing with me is that they have trauma from court, and it's so traumatic and so blindsiding to go to family court and see how crazy it is. Like somebody falsely accuses something like the Duke Lacrosse Five or not Duke Lacrosse team or the Central Park Five. You know, those kind of that kind of level of trauma is probably the same trauma that the average dad suffers in a family court. And really, most guys' gripes with me are like, you don't understand my pain. You need to feel my pain. No, I don't. If I got the answer and you want to go to war, let's go. Here's some tools and weapons. But I do understand because I've been through it. And I was dragged in and out of court. Like some of the motions I did myself, contempt and motions for child support because she was making great money or whatever, living high off the hog, not involved with our kid. But you know, I was often dragged in court and falsely accused after I got custody. So there was torment that was going on even after I got custody. And then I had to listen, and I was doing this stuff. And then I had to listen to people's stories all day long. Like, and you guys act like, oh, you don't understand. You're a low IQ, airheaded mother effer if you think I don't understand. And I was in and out of family court in my own case for 19 years, and I've dealt with 25,000 cases. There's something wrong with your retarded ass. So these guys that hate on me, yeah, you got trauma. I'll never deny. I just did a video like I understand trauma. I just was on a group call yesterday with some guys that had some crazy stories. They got some real trauma. But the more they talked about their case, the more I realized they did some stuff and they agreed to some stuff that screwed them. I never did that. My guardian life said, why don't you agree to domestic violence counseling? I'm like, F you. It's not what you think, James. It'll teach you some skills to get along with the mother so that you guys have to co-parent. This is after we were setting up to finalize things for custody. I said, I'm not doing that. I'll take a conflict resolution class. What are you going to make the mother do? See, because I have some balls to question what people say. Most of you guys stay silent. Okay, guardian light, whatever you say, I have to bow down and worship you. You guys have too much of a high-minded view of all these other people. And you empower them sometimes by you being intimidated. So I said, I'm not doing that crap. And then I went to court and I motioned the court because she wouldn't sign off on our order to get it in. I told the court, I got some medical issues I got to deal with my child's special needs. And this lady is stopping us from it. And then the commissioner put her on the spot. She said, okay, fine. But in the hallway, she was trying to get James, we could sign off on this and just get it done. Like, mother effer, I'm already here in court. You inconvenience me. F you. Anyway, so American Father, you said Dad's America. Well, yeah, dadsamerica.org. Some of you guys know how to do a shadow thing or a ghost page where you look at old websites that are gone and there's still something lingering on the internet. If you could do that, you'll see dadsamerica.org. It's gone, so I don't have any proof of it. But or if you type in Bob Carl's Dad's America, it's really Dads. The DADS was Dads Against Discrimination. And now there's a new group out there that bit off of that name because those guys are gone. One of the guys lost his mind. He's waiting for the aliens to come get us. Another couple other dads in the headquarters in Portland. They had like 13 chapters across the country. Alaska, Washington, Oregon was the headquarters. There's actually a guy in New Jersey who's left over. He used to run New Jersey's chapter, and since they fizzled out, he still does his own thing, helping dads out there. Sometimes I refer people to him. He's way more expensive than me, but he knows his stuff. I know there's a Michigan chapter, I think, Mississippi. There's like 10, 12, at least a dozen chapters of them. The best father's rights group I ever saw was in Las Vegas. I visited their office. They had a staff about, I don't know if they were volunteers or they worked there, but it was like 20 desks of guys helping other guys. And there's one receptionist that was a woman, and they had a sign that said no women allowed. They didn't allow people in there. And the guy who ran it, he's a friend of mine on Facebook. I barely know him, but he sold that business over, or the building over, to an attorney who promised to keep the father's rights legacy going, and he didn't. I don't know how the dude even gave up on it. Like, why didn't he keep it going? But father's rights guys, they get burnt out after 5-10 years. Bob Carlos was probably around 20 years. I've been doing this since 2001. And I've seen the father's rights movement groups. They just recycle people. Some guy who went through a divorce and stuff, like, ooh, here's a movement. See, they go to court. This is the cycle. You go to court, you're so traumatized and blindsided. You think you're isolated. Nobody else can understand what you're going through. Your friends and family who've never been through family court have no idea. And I had a friend who made fun of me, like, here's my invitation to James. Hey, how you doing? I'm James. You know how corrupt the family court system is? And the family court does this and the family court does that. Because that's all I could talk about, because I was so traumatized and shocked by it. So they're so shocked, and then they see that there's groups out there, like, oh my God, here's the group. I felt so isolated and alone. Now there's a movement. Oh, I could feel things are going to change. I just know it. I feel it in my spirit. I feel it in my emotions or feelings. And people have been saying that, and those guys, after about a year or two and nothing changes, they get burnt out and they move on. Or maybe they're part of a chapter of the father's rights movement. There was a guy in Washington in about 2010. He loved going to the legislature and taking photos with his representative, and he was getting all sexually aroused over all the attention he's got, and he's gone. He was gone within a year. And I told him what he was doing was bullcrap and it wasn't getting anywhere. He didn't, and then I'm the jerk, but he's gone, and here I am. You see how you see how I say this stuff is insane? I'm still here, and all these knuckleheads came talking all this emotional crap, and they had this emotional high. Oh, there's a group, and we're going to pass a law, and everything's going to be fixed. And then it came crashing down, and now they're gone. And when I warn people or tell them, they say, you don't know what you're talking about. Or Present Father, or actually Present Father made a comment on his page, and he said, I appreciate what you're doing for men, James. Really? Is that why you got me blocked everywhere, dude? Or is that a save face comment that you got in there to make me look bad because I called you out? David Passara, $800 an hour, family law attorney. He doesn't go to court anymore because he gets his ass handed to him. So now he's doing the dad's law school stuff. And he tells you, you can't go and do contempt and you can't win contempt. And I called him out like 8 years ago when I saw him on Instagram. He said, Dad shouldn't do contempt. And I said, bullshit. I won contempt without an attorney on my first try. And I've had countless other guys do it. And he's still out there preaching that you can't get contempt. This guy is so delusional. I should have done a video. There's a thing with this System mentality. The way the system is what we have to work with. Bullshit. I'm going in there and looking at the law, and if the system is ignoring the law, I'm waking them the hell up to what the law says and my rights. David Bassara says, here's how to work the system. And he's got this book for $45. Bring pictures to court. Tell them you know the name of the babysitter and the doctor and all the teachers. All this basic common sense, legal 101. You know, my sister with Down syndrome can write a declaration the way that he has it structured. And he basically promises you're going to get more time. Nobody can guarantee that. Now, I kind of guarantee stuff like you will do way better, or you have what I say is you have the best chance to get something fair in your case if you do this. If you don't do it, it's a loss. Just like if you keep eating the same diet and don't exercise, you will remain fat. Now, if you exercise and you have a disciplined diet, you will get better. You might lose weight fast. You might be up and down, but you will do way better than just sitting around doing the same thing. Doing the same thing, doing the loser route is an automatic guarantee. And people want guarantees for the unknown in the future. There are no guarantees, but the stuff that's worked for me in thousands, again, this is stuff that I know stories of. People fought like I did before me and got full custody or got 50-50 or fought off restraining orders. Then I did it and people after me. And I stopped counting at 300 dads in about 2018. And a lot of guys would call me up like 2 or 3 years later. Hey, I meant to ask you a question. Oh, by the way, I got full custody. Like, you didn't want to tell me that, dude? I mean, I don't expect anything from anybody, but you would think that some things they would say, hey, I got full custody. I just want to say thanks or whatever. I almost have never gotten any donations, even though I have donation tabs. I guess maybe I have to push that. It would be cool if all my followers on YouTube gave like a few bucks a month, then I could basically do one-on-one consults live all day long for 8 hours and give people stuff for free. If everybody pitched in a few bucks, but you'll never get anybody to do that. It'd be nice if we could do what's idealistic. But anyway, let me get to okay, that was mine opening. Sounds good, bud. Drew said, James, hands down the best. Listen to this upfront, truthful, helpful knowledge. Thanks, man. Dad's America, American fathers. Tough dad, Ryan the tough dad is already quitting because his ex told him to. What? Because his ex told him to? His ex that he got 50-50 with told him to quit going on social media? Now I can understand if you have a contentious case, and like I'm surprised Randy Keith from Present Father, he bashed his ex-wife on social media and told all her business for a year. If she was smart and wanted to be, now I'm not advocating for her to do this, but if she was smart and wanted to get control, all she had to do is say, this guy's going on social media and bashing me, and the kids can see it one day and look at what an alienator he is, talking bad about me and all this other stuff. But she didn't want the kids. He's lucky. And then he talks about, oh, you got to be smart. And he has like something you can buy for like $30 that says, here's the 15 things you have to say in these 15 scenarios. And he went through one custody battle and he got lucky because now people say I got lucky. He wore her down because he still kept at it. And he was able to afford an attorney to keep going and keep going. But at one point she said, oh, he can have custody because she moved away for some boyfriend or whatever she did, moved back. She moved 400 miles away. She's like, she didn't want the kids. She couldn't handle them. And it wasn't because he didn't give her a chance. He gave her all kinds of chances, offering 50-50 to somebody who was almost off herself and continued to alienate the kids. And he's whining and crying. I can't believe she just alienates the kids and talks bad about me and puts the kids in the middle of it. Bitch, you gave her 50-50. And then now he's like, I got custody, but she has 4 weeks on, 4 weeks off in the summer. Bitch, you told the court she can have 2 weeks on, 2 weeks off. That means you find no problems with her parenting or nothing wrong with her. How can you be that stupid? $250 an hour. That's insane. I wish I could charge $250 an hour. I just can't do that. I mean, I could. And if I just get, keep going with like one consult a day, I'd be good. I just can't do that. So American Fathers is telling me that Ryan the Tough Dad, for those of you guys who don't know Ryan the Tough, if you just Google Ryan the Tough Dad, you might still be able to find him. There's articles about him. He was one of the leaders of the Fathers' Rights movement because he's out there on social media. There's an article of him about 3 years ago before he got 50-50. It took him 7 years and $25,000. Now, congrats to him for getting 50-50, but it took him that long to do it. I got full custody in 7 months. But he's more popular and people love him more because he goes on there and like somebody wins in court or something great happens and he does a little dance, like a solid gold dancer or a booty clapper in a hip-hop video. Judge Anthony does that too. He does all these little attention gimmicks or whines and cries about the system. And, if I just whined and cried about the system, I could have hundreds of thousands of followers. But then when I tell the truth, none of them would like it. So I'd just rather be honest and be organic and not do all this fake shit these guys all do. I guess said it's affecting the kid. The ex and the therapist says it's affecting the kid, which is probably BS. Basically, the other kids said they saw their dad's videos. Now it's a problem at school. Look at all that hearsay bullcrap. The kids, here's where people, if Ryan the Tough Dad had any sense of the evidence rules, there's no way that should be allowed in court. The therapist is saying there's a problem at school where the therapist doesn't sit and watch the kids because dad is on social media talking about stuff. Basically, other kids said they saw. Now it's a problem at school. That's another thing to attack any expert. Tell me how you know the cause and effect of this. When I did this, or especially if they say we don't like your antics in court, so I'm going to take your time away. So you're gonna starve the child of a basic life need of the nutrients or medicine of a father that they need because of what I'm saying to you and her in court. How can this possibly affect the children unless the mother's running back and telling them? What's the cause and effect, Your Honor? How does me saying something in court and being adamant affect the children where you're going to deprive the children of a father and it's better for the children to not see me because of the way I talk to you in court? What if I'm perfectly loving with the kids outside of court? Why would you do that? Why would you do this? I'm going to starve the kids of a basic life need because of the way that you talk in court. Where's the cause and effect? And if you say that affects the children, then you're acting like an expert psychologist. You can't testify, and even you can testify, you're violating the rules of evidence that you're not expert psychologist on the issue. Where's the cause and effect? They never give you the cause and effect. They just say it, and because they said it and it's tradition, you're dealing with the culture of the court. And I tell people, you're dealing with the culture of the court. Call BS on the culture of the court. But most people don't do this. And then they go to court. They don't try. They give half-ass effort, or they have a stupid-ass attorney. And then when I say you can win, they're like, bullshit, I went to court and I lost. Well, you're a dumb mother effer who can't self-examine and say, maybe I did something wrong. Maybe James knows something. Or your ego is caught up in it, or you got feminine emotions. They want to insult me because I won in court and I did what you want to do. And then you're disrespecting and crapping on me. Is it possible that you did something different than me? And I might have done something that worked. You're just so traumatized that everything is viewed through your, just like a judge, everything is viewed for the judge's prejudice. If she's a feminist, everything is viewed through feminism. When you see somebody like me, everything you see is viewed through your trauma. Wake the F up and actually care enough about your kids to humble yourself and say, maybe there's something else I could do. Maybe I should get help from James. But if you don't, that's your loss. I mean, I got my kid. I don't need to be here. I got my kid. We had a happy life. We had some bumpy roads during teenage years. We had bumpy roads when she was questioning why her mom abandoned her. I tried to do what I could. I made plenty of mistakes I still regret. But I had my kid. And she just texted me. She's like, when are we going to go to a Seattle Mariners game, Dad? Even though she's on her own in 23. And, when I was that age, I didn't want to hang around with my parents. But I've been her whole world. And she wants to see me. Like, there's periods of time where she comes down here, like, 3 or 4 weeks in a row on her days off. And she has friends and other people to hang out with, but she'd rather hang out with me. And she sees her mom like once every couple of months now that her mom is back up here. Don't you at least want to think about possibly trying to find out what I may have done that you didn't do? Nah, James, you mother effer, you just talking blah, blah, blah. That's your loss, dude. Let's see. American Father says, I think it's a scheme to sell his merch and push people over to Sean's page. Oh, Sean, what's his face? The miraculous counselor who talks to 8 guys a day. If you guys know what I'm talking about, or what American Father is talking about, Randy Keefe has had several different guys on his show, and they're all in this little clique, and they all do the same thing. Oh, we're going to change the system. Oh, it's just us. Oh, guys like James and other people outside, they're a bunch of con artists. And then they just straight up lie about me. Like David Bassara, the other Dad's Law School. So Randy Keefe from Present Father had David Bassara from Dad's Law School, who says you can't do contempt and you can't talk about alienation. That's everything. That's almost every issue a man has. And he's saying, don't talk about it. What a mother effing house slave bitch sellout. Robert Garza wants to charge you $300 to $450 an hour to learn how he fought for 15 years and spent $700,000 and got his kids taken away 43 times. Do you want to learn how to do that? I got full custody of my daughter when she was 7 months old, and my custody case would have been faster if I knew the stuff I'm teaching you guys now. Way faster. It took me, I did a contempt motion. The first contempt was in June. She violated in July again. And by the time I had a contempt hearing, it was bumped later to September. So it took me 3 months to do contempt. I'd have been in court in 2 weeks if I knew what I was doing. I didn't know what I was doing. There's actually people who say, well, I don't know what I'm doing. I can't represent them. I didn't know what I was doing either. And I did not have a James Christensen or How I Got Custody or all these resources out there. And I had to go to the law. I had to drive my car to the courthouse, to the law library, to the mother's attorney on the other side of Lake Washington, doing 100 miles round trip just to get my stuff filed. You guys can literally do your entire case in your bed, not your bedroom, in your bed. Write up declarations, have your friends send a signature over, and then you work with them just like a law firm does. Do everything from your bed. E-file, e-serve the other side. It's a million times easier than when I went through it. You don't have any excuse. There's no excuse to not fight as hard as I did, because when I fought that hard, it was hard. I had to go to the law library and open up books to read case law and shepherdize stuff. You know what shepherdizing is? You could do that now online for free. You don't have to drive anywhere. Anyway, American Father. Oh, so then there's Randy, Robert Garza. He had this other guy on who says they're going to pass a 50-50 law in South Dakota. And I said, dude, that's bullshit. And then he hated my guts and blocked me. He's an idiot. He's also another rookie. I forget what his name is. It said that the title of that YouTube video, if you type in Present Father, there's Present Fathers on YouTube, and Randy Keefe is Present Father, the guy who looks like Grizzly Adams with the blonde beard and the baseball cap. He had Ryan the Tough Dad on there. He had this other guy from South Dakota. He passed the bar, but they wouldn't give him a license. Ryan the Tough Dad. The dude from Dad's Law School. Oh, yeah, and then Sean Pearson, who was running around Facebook because he was working with the Father's Rights Movement. Oh, God, I still got to talk to this dude. There's a guy in Washington who was working with Sean Pearson. Sean Pearson says, stop doing what James is talking about. Just trust the guardian ad litem. And he was like, F you, dude. I'm going to attack the guardian ad litem. And he destroyed the guardian ad litem, and he got 50-50. If you were listening to Sean Pearson, he would have lost. Sean Pearson doesn't know what the hell he's doing. A lot of people think he's mentally ill. But they're all in this clique, and they all gatekeep, and they like, we're the Father's Rights Movement now. We're running shit. We're the big mafiosos, and we're the La Familia, and we're, you know, I don't know who's the godfather behind the scenes, but did somebody say something on Facebook? Oh, hey, Fernando, if you're still there. Thanks, John. I see that comment on Facebook too. But so Randy's had a bunch of guys who've lost in court or it took them forever to win. And then I'm the asshole because I don't buy their lies and I don't buy Randy's thing to whine, cry, piss, and moan about the system over and over and over and over and over and over and over again and take it up the rear for years and hopefully and not clap back and not call out alienation or intransigent, abusive use of conflict like mothers do all the time. He's like, don't call it out, don't say anything, be quiet, be quiet, be quiet, be a bitch. That's Randy Keith's thing. And he had a mentally ill suicidal maniac. And so it was a little bit easier for him to deal with that because she can't handle the court stuff. And he had plenty of money and he took it from his kids' education fund. And like somebody told me, you know, I mean, like I know he's a cop now, but somebody made a point like he might be out arresting guys for DV and he'd be in a sellout. He's part of the system. Hopefully he's waking people up in his police department. I mean, I can give him the benefit of the doubt on that. I don't know, but you know, he does say some stupid stuff, analyzing stuff. So yeah, Ryan the Tough Dad is a pushover. Randy's now pushing people to Sean, he said on a recent live. Wow. I mean, I still don't even know what Sean does. Like, do you know what Sean does besides just be there to be an ear to listen to guys? Because that's all I got out of his podcast. And Randy Keith, the title of his interview with Sean Pearson was "The Guy Who's Talked to Thousands of Guys, 15,000 Guys." Okay, what did they get out of it? You know, like I said, I stopped counting 8 years ago the number of dads that helped get full custody, mostly without an attorney. And there's 300 of them that I could count. There's probably plenty more don't get back to me. Some don't get back to me for years. I just, you know, heard from another guy, like I said the other day. Or I heard another guy on YouTube. If you look at the testimonial I just posted on all my social media showing you that YouTube comment, and I don't know a single attorney who's helped more than 10 dads get full custody. There's some of them. I had a client who wrote up, he said, I want you to cite Troxel versus Granville in court. And he goes, where did you get this from? Oh, actually, it was some Washington case law that everybody should know. Where do you get this from? I'm not going to argue that. They said, oh, I got it from this guy named James Christensen who got full custody. Oh, he's an idiot. He doesn't know what he's doing. He's not an attorney. My guy gave his lawyer a piece of Supreme Court case law in Washington. The Supreme Court said just because the mother was a primary caretaker, she doesn't get custody automatic. And the lawyer dismissed Supreme Court case law because I showed it to him. And then I asked the guy, I said, well, how many dads has this lawyer gotten full custody? He said 0. He asked him and he said 0. This is the insanity of this stuff. You would think they would listen to a winner or somebody that's helped other people win. And guys who have lost hate on a guy who's won, and they got no reason to do it other than they just don't like it. It's insane. So Randy Keith refers people to Sean Pearson, who's running everything behind the scenes and he's probably trying to use those guys to get his clients. I don't even know. Randy Keith was trying to act like Sean is free. I don't know if he makes money doing this or not. But you're telling me that they tell people to hire lawyers. They just blindly trust lawyers. And Randy Keith blindly trusted his lawyers, except when his lawyers told him, dude, put your ex-wife on supervised visits. Randy Keith said, no, children need moms and dads. Gave her 50-50 and she alienated the kids for a year and tortured and tormented them. And he was whining and crying about it. But he says, trust lawyers. And he didn't trust his lawyer. Those guys are just there's no sense to this stuff. Doesn't make any damn sense. Some nut job who went through family court, was stupid enough to keep having kids with crazy women or whatever he did. He had a couple kids with a crazy woman. Right after his divorce, he's with another woman in a blended family, which is insane to me. Like, why don't you take your sweet time, dude, and like recover and make sure you don't have all these responsibilities? And, you know, the second wife, if you got a good second wife, great. It happens sometimes. But I've seen a lot of marriages and relationships be destroyed because the wife or the woman, she's not afraid of your ex, but you are. And she gets sick and tired of you getting ran over and pushed over, and you devoting all this time and energy to the old relationship and the toxicity. And you got a supportive woman. This women, I get all kinds of women and grandmothers who call, my son or my boyfriend, this and that. I'm like, well, he's got to fight and do this and that. No, he doesn't want to do that. Okay, I can't help him. Yeah, and they're mad at him. Like I've been telling them to watch your videos and he won't watch them. I had a mom who called me up and sent me some stuff. Her son wouldn't listen to me, wouldn't do anything. Paid an attorney, got railroaded in court, wouldn't even look at my videos. And she's been watching me and loves my stuff. And now he's royally screwed. And we talked about what the attorney did in court. I'm like, why didn't you guys get some briefing on me like before court to make sure the attorney did certain things? He didn't want to. Like, not everybody wants to be saved. That's the way that it is. You know, sometimes people have diabetes. They still want to eat sugary foods all day long or whatever. Not everybody wants to be saved. You're the only one who can rescue your kid, and you don't want help doing it. That's insane. Anyway, I better jump off of here. So thanks for coming in and watching. Thanks for your questions. Hopefully I enlightened some guys. And if you need a one-on-one consult or if you needed more information, watch my YouTube channel and type in topics there or get a one-on-one consult. My contact information is, hey, Lars, said winner on there. Just check out my contact information. It's, Derek says, thanks for your time, James. You're welcome. In each Facebook post, under each YouTube video, my flow page, contact information, links to all kinds of free stuff. It's basically kind of like my website. It's like a link tree. It's kind of like my website. Everything's in there. You can navigate it on your own. It's going to take you 10 to 100 times longer to figure all that stuff out and master it than it is if you get a consult. So it's worth it getting at least one consult. Nobody's ever regretted it except for guys who were mad that I told them they had to do certain things and they didn't want to do them. And I was like, that's the only way. And I've actually ended some consults and given people money back when they were just fighting me and telling me, you don't know what the hell you're talking about, or I can't call my baby's mom out, but they're abusive and I want the kids, but I don't want to call her out because she'll call me out and I'm afraid of that. And I'm like, dude, I can't help you then. Once they started admitting that, it's like somebody when I realized it's somebody I cannot help because they don't want to do anything that they should do, then I just got to bail. So Shay, appreciate you, James. Thanks. Appreciate it. Okay, I'm going to jump off here. You guys keep fighting the good fight.